there were proposed orders submitted by Ms. or prepared by Ms. Powers, and I wanted to double check with Mr. Brooks to see if you received a copy of those proposed.
I did. I have some questions and some things because I'm doing this pro se, so I've done some reading to try to know what my rights are as far as this matter.
Okay. So when looking at these proposed orders, generally what we're looking for from all the parties is that this is an accurate summary of the findings or the rulings from back on September 11th. So in kind of with that as being the focus, when you looked at the orders that Ms. Powers prepared, do you feel that was a fair and accurate summary of what the court ordered or not?
No, there's a couple things that I had questions about, like when we were in court. I don't know if it was a guesstimation on your part when you set the order for $500 a month. When I got the paperwork from Ms. Powers, that it was saying $570.60 a month.
Mm-hmm.
I have bank state or my check stubs or whatever proving my what I make a month. And then under what I was reading, it states that there, that it was having a court ordered child support order is a violation of the law, and that it's like a rush to judgment, and that I could ask for a hearing through DSHS or the child support enforcement to have it reviewed so that it is proper. I have no problems with paying child support, but I don't even make enough money to be able to pay $570 a month. 500 was that's even making it rough with my bills and everything else too. I don't make a lot of money either.
Mm-hmm.
I'm not trying to get out of it, but I just want to make sure that I'm getting a fair shake.
Yeah, absolutely. I hear what you're saying. So one thing you mentioned, I jotted down a few notes when you were speaking. So the child support order, you said that was a violation of the law?
Yeah. When a judge orders child support through the courts, it is a violation through the courts. That has to be done through DSHS. I don't know if I'm right. I'm just reading. I'm doing this pro se, so if I'm wrong, then I stand corrected. But under constitutional right, I have a right to a hearing through through the federal part of it, which would be child support enforcement.
So yeah, you're right. There's two tracks. There's two separate tracks. One is what they call an administrative track. The other is a legal track. So either can be put in place. What I see often is that the administrative track happens first. Like a parent will say, "Hey, I need child support," and then administratively, the Division of Child Support goes after the other parent and gets an administrative order put into place.
Okay.
Then when somebody says, "Well, hey, I want the legal track," then the legal track, somebody can petition the court and ask for child support to be paid or the like. And so Ms. Powers is on the line. Ms. Powers, who is representing the opposing party, she previously worked for the Division of Child Support. So Ms. Powers, do you have any additional insights that you could share with Mr. Brooks? Sorry.
I think the only thing I would add is that under the Constitution, you're given notice and an opportunity to be heard, and that's what happened at our hearing last time. We had given you notice. We were requesting child support, and we had a hearing, and you had the opportunity to present your information. My notes do not say that the court made a specific order about a transfer payment, but the court made specific orders about the parties' incomes and set the mother's net income at $2,000 a month and the father's income at $3,000 a month. So when child support is calculated in the state of Washington, whether it's done administratively or in the court system, it's based on the incomes of the parties, and you put the incomes in, and the calculator spits out the child support payment. And so that's what we did in this situation.
And then I was also going to just mention, Mr. Brooks, that, and Ms. Powers, you can correct me if I'm wrong, that if there's two orders, say there's an administrative order that we talked about before, and then the legal order, that the legal order trumps the administrative order. Is that accurate, Ms. Powers?
That is correct. So if the Division of Child Support had entered an order, it would be trumped by this court order. And now that the court is entering an order, the Division of Child Support does not have legal authority to enter or change the child support order.
So do I still have a right to have a hearing through child support? And
the administrative side of things? at this point, if they were to try to enter an administrative order, it would be of no effect because there's a hierarchy. So administrative orders are less than court orders. So the court order is a higher order, and therefore it says basically, we've taken the field, administrative orders, you're off to the sideline. So, and then also keep in mind, this is a temporary order. A temporary order means that it's temporary and that you have a right to have a full trial on the issue of child support. And so then you could have additional opportunity to provide additional information. But at this point, it's a temporary order that is based on the court's earlier ruling from the 11th of September. So what other questions do you have if we didn't answer?
I mean, this is a temporary order. So my other question was, I know that we have Ms. Height as our GAL. We'll have some interviews, some paperwork that I've sent to her in the mail. As far as that, like a more set in place parenting plan where we can sit down with like a mediation to where we can come to an actual agreement instead of my time being limited with our son.
Yeah, there's several ways to achieve outcomes when there's a disagreement on parenting time. When parents, well, there's several possible resolutions. One is that the parties can work it out themselves and come to an agreement and either go to court and present it or just live by the agreement that they've made and just it's off the record and they just do it that way. If the parties want to come to an agreement, and I'm always a firm proponent that you and the mother of the child have a much clearer picture of what's going on than I ever will. You're a lot closer to the situation. And so if you're able to come to an agreed resolution of the matter, then you can fill out the parenting plan and agree and have the court sign off on it. If you can't come to an agreement, then your other options would be go through a mediation and see if the parties can give and take a little bit and see if you can come to a resolution. And if you can't, then you come to court and ask a third party, a judge, to make a decision based on the information that's presented. So agreement is definitely encouraged. Mediation is definitely encouraged. And if those don't work, then you come to court and say, hey, we turn it over to your hands to make a decision because we can't. So I don't know if that answered your question or not.
Yeah.
Okay. All right. So then taking a look at these proposed orders, there was the parenting plan. Did you have any objections to the proposed parenting plan that was presented?
No, until we can, like I said, I'm doing everything pro se. So like what I'm reading, I'm just trying to have an understanding of it. Being pro se, I know that I need to try to make an appointment to talk to Ms. Powers, so that we can come to some kind of agreement on certain things and maybe make some appointments where there's some information exchanged so that this can be cleared up.
Sure. Yeah, that's true. That would be the person, since Ms. Grandchamp Brown is represented, then your negotiations would be with her representative. So,
Yes, sir.
Right, Ms. Powers, that's correct. So if you don't have any objections to the proposed parenting plan, I'll sign off on that. Then regarding the child support, there's the worksheets and then also the order. At the hearing, the court had made a ruling on the temporary order that found the nets of 2,000 for Ms. Grandchamp Brown and 3,000 for Mr. Brooks. And based on that, there's a standard calculator that everybody uses, and you put in the numbers and it kicks out the resulting child support amount, which is that, I think you said that 570. So other than those things that you mentioned earlier, the questions that you had, do you have any other questions or concerns?
For the temporary order, I would like for it to be just taken out of my checks from work.
Okay.
Like where it's just garnished.
Okay.
I would like to, so that it doesn't interfere with my other bills that I have.
Right.
Cost of living, things like that it be split up in 2 payments. Every 2 weeks.
Okay.
Would be like 280 something 30, something like that.
Right.
285.30 or something.
Okay. Ms. Powers, do you want to address that issue as far as the automatic withdrawal?
Yeah, Ms. Grandchamp Brown signed the application for DCS to collect the child support. The Division of Child Support will send a notice to your employer and will automatically take out equal payments from each paycheck. It usually takes about a month after this order is set up for all of that to get into place.
Okay, so my question is you had set that the child support start on September 1st. I'd missed now going on 5 days for court to be here. My last check that knocked me about $546. I don't have $570 for this month to be given for child support. Like I physically don't have that money.
Right. Yeah, understood. Often what will happen with orders that are somewhat retroactive, that people are in real binds, cash doesn't grow on trees. And so that there may be an arrears that's in place for a month, and then recognizing that you've missed work and the like, and then that arrears just has to be kind of taken care of over time. So
Yeah,
kind of nibbling away at
I
it.
just got my driver's license back. I paid to have my driver's license.
Right.
I'm just not trying to be delinquent on something which I know is my responsibility. He is my son, so I have no problems with doing that. But I just don't want to be put in a dead-end situation where like I can't climb back out of that hole.
Yeah, I hear you.
Your Honor,
So-
could I provide additional information?
You may.
So when Your Honor signs the child support order today, it will go to the clerk's office, and the clerk will forward it to the Division of Child Support within the next day or so. The Division of Child Support will open a case, and either party can call the Division of Child Support with their identifying information, and there will be an assigned support enforcement officer. If Mr. Brooks talks to his support enforcement officer, DCS is really good about making payment plans around paying arrears at a small amount per month, if he'll communicate with them. If he doesn't make communication with them, then they have their own algorithm and way to calculate how they're going to withhold the back support. But if he'll talk to them, DCS is really good about working with people on that.
So hopefully that's of some assistance, kind of recognizing the realities and the like. Other than those concerns with the other proposed orders that were prepared by Ms. Powers and sent to you, do you have any other concerns or objections?
No, I just know that after I talk to Ms. Powers, I'm sure we'll figure out what we need to do next.
Okay. All right. Well, I appreciate your questions. Thanks for your conscientious approach to things. I've signed off on the proposed orders, as I think that they represent fairly what happened at the last hearing. So I'll give those to the clerk, and then those will be filed. And if anybody needs copies, you can check with the clerk and get copies of them.
So that like later on today, I'd be able to get a copy of that from the clerk and all that stuff, or that, and then like she was just saying the child support enforcement deal, like getting that kind of information so that I can contact them and try to figure this out.
Yeah, and contacting them, Division of Child Support, you could do a simple Google search, and I think on some of the paperwork there's actually phone numbers for them. Division of Child Support.
I would be happy as a courtesy to have my legal assistant watch, and when the orders are available in Odyssey, we'd be happy to mail Mr. Brooks copies of the orders today.
Okay, that's another option too.
I would greatly appreciate that.
Okay. Yeah, that sounds great. Sounds like that courtesy will be offered and followed through with, and then you'll have those. And then just do a Google search for, Division of Child Support, Washington, and then they can look you up, and then you can talk to them about making those arrangements as far as payment plan and like.
Okay.
Okay. All right, Mr. Brooks, thank you.
Thank you.
Thank you.
There we have Mr. Lawrence present, guardian ad litem, Ms. Holder, she represents Ms. Rhodes, and Mr. Jensen. He usually comes in person. I don't see him here today. But the request is, we're on today for a presentation of orders. Let me just get my notes up here, and I'll hear from Ms. Holder. Go ahead, Ms. Holder.
Yes, Your Honor. Mr. Jensen is in the Zoom box. My office spoke with Mr. Jensen yesterday, and I spoke with Mr. Lawrence. I've been sick the last few weeks, so if I could request a set over, I was unable to get those orders drafted and over to Mr. Jensen. I should need just about a week.
Okay. And then let me just, Mr. Jensen, can you hear me okay?
Yes.
Okay. Were you able to hear what Ms. Holder said and what her request was?
Yeah, I did.
And if we were to set the matter over for presentation, the requested 1 week, do you have any concerns with that?
No, but I was just wondering because we have child support too, I was wondering if we could include all of that so we don't have to continue to come to court every other week.
Yeah, coming to court is not people's favorite thing for sure.
Yes. If the court would allow me to, I can absolutely run those child support numbers and get a child support order and send that over along with the proposed orders, and we can address that issue next week. It'll be the standard calculation.
So basically what we're, in response to your question, Mr. Jensen, is the proposed orders Ms. Holder will get those to you. If you agree that they're an accurate summary, then you can sign off on them. They'll be forwarded to the court for signature, and that would omit or obviate the need for you to come to court next week. If both you and Ms. Holder talk about child support and you're agreed as to child support, then those orders could be signed off and they'd be forwarded to the court, and that also would obviate the need to come to court on October 2nd. I am going to set the review hearing for October 2nd as a backstop, if you will, and that will allow the parties to discuss, and if you can come to an agreement, great, then we can strike that hearing and nobody has to come to court on that day. However, if there's non-agreement with the proposed orders and also the child support issue, then both parties would be here to express their respective opinions.
Okay.
All right. So we'll set the matter over to October 2nd for that purpose, the presentation and potential resolution of the child support issue. And I'll ask Mr. Lawrence, do you have any further items?
No, Your Honor.
Okay. And Ms. Holder, any final items?
No, Your Honor, nothing for me.
Mr. Jensen, any final items?
No, sir.
Okay, we'll potentially see everybody next week and potentially not, but we'll set it for that date. Thanks.
All right. Thank you.
Thank you so much, Your Honor.
08.
Thank you, Mr.
I'll
Jensen,
ask
Mr. Lawrence.
if the
Yeah, bye.
parties are
You.
present. I see Mr. Lawrence is present. He's the guardian ad litem. I'll ask if Ashley Becerra is on the line.
I am, yes, sir.
Okay, welcome to you, Ms. Becerra. And Joseph Becerra, are you on the line? All right, Mr. Becerra, if you're speaking, I can't hear you, so make sure that you're unmuted, and again, just state your name so I know you're present. All right, not hearing a response or hearing from Mr. Becerra. Looks like there's no movement in the courtroom, so I don't see him here. We're on today for a pre-trial in preparation for the trial that's set for the week of October 14th.
Yes, it's to finalize our divorce. It's been in the works for 5 years, almost 5 years now.
Right, yeah, and today's effort is to make sure that everybody's preparing for the trial, which is scheduled for the week of October 14th. And so I'll ask you, Ms. Becerra, do you have any questions in relation to your preparation for the trial related to witnesses, exhibits, and things of that nature?
No, we separated due to sexual from my husband to my daughter. And so we've been separated, like I said, for almost 5 years now. All of our assets are separated. We've gone through the parenting plan, custody things with our son. He didn't follow through on his stuff, so he's no longer allowed to see our son.
So, and then
So
in
it's pretty
preparation,
much just waiting for.
yeah, so in preparation for the trial, there's a couple of things to keep in mind that generally parties will have a list of witnesses that they plan to call, and they'll have a general idea of what that witness is going to say. So they're kind of planning out their case. So you'd have a list of witnesses and make sure that they're in attendance, giving them notice. That's one thing to prepare for, and then be prepared if you have any documents or pictures or videos or things of that nature that you want to have the court look at. And you'd need to have a copy for the court, a copy for the other party, and a copy for yourself. So just make sure that you're prepared in that manner. Then also be aware that you can call witnesses, and you can also be called as a witness by the adverse party, and likewise you can call them as a witness. And be aware that also that after you've presented all of your evidence and you've testified and he's testified and witnesses for each have testified, then you'd be called upon to give a closing argument, meaning basically you would lay out your reason or rationale for why you should be the prevailing party. The other party would have that same opportunity. And then also if you want to prepare proposed orders, a lot of times people will prepare proposed orders in the fashion that they feel that the case is going to go in their favor, and so they'll prepare those and have those ready to go at the time of the trial. That's something that's helpful for the court also. So if you want to do that, you're encouraged to do that. Last thing I wanted to ask, Mr. Lawrence previously filed a guardian ad litem report, a couple of them, it looks like. The last one was filed on December 13th of 2020.
Yeah, locked up.
Pardon me?
I think he's having difficulties with his
Zoom.
Zoom. Yeah.
Your Honor, I apologize. My screen locked up. I didn't catch what you asked.
Oh, I apologize. I was just mentioning that you had filed two guardian ad litem reports, one in 2021 and the other in December of 23. I was just teeing that up to see if your presence was required or if the parties would be relying upon your report only. So I was just kind of teeing that up. And obviously, if you wanted to be there, I'm not going to prohibit that, but I just wanted to touch base with Ms. Becerra, what her thoughts were as far as your attendance. Ms. Becerra, do you want Mr. Lawrence to be there to testify live, or do you want the court just to simply rely upon his written reports?
I'm okay with him being there live to testify. His report has pretty much solidified our parenting plan, thanks to his investigations. I don't understand why this is such a big deal. It's literally, we've been separated for 5 years. We have nothing to do with each other other than our son. I'm literally just asking to finally not be this man's wife anymore. So I don't understand what orders need to be put in or anything like that, because I've already submitted the divorce decree and all of those papers prior.
Well, we're going to have a trial. We have a trial. The court needs to make findings of fact and conclusions of law, and that'll be based on the evidence that's presented. And when the trial's done, then you'll be done. You'll be divorced, and everything will be in writing. So the next court hearing is on October 8th at 11:30 a.m. That's to make sure everybody's ready to go. So we'll see everybody on October 8th at 11:30.
What happens if Joe doesn't show up again?
Generally, those tend to be fairly short trials. When we go to trial and one party is not present, then this court still needs to make findings of fact and conclusions of law. So one party presents their side of the case, and that's all the court hears. And generally, that goes well for the one party that's present.
Okay.
Okay.
Your Honor, I have a request. Normally, it takes about 3 hours of trial prep and an hour for appearance in court. Would the court consider granting me 4 hours of time to get set for the fact finding?
Sounds reasonable. I'll approve that.
Thank you.
Okay. All right. So we'll see everybody at the readiness hearing October 8th at 11:30 in the morning. Thank you.
Thank you.
Okay.
It sounds like Ms. Giles is on the line.
Yes.
Okay. Welcome to you. And is Brandon Connolly on the line?
Yeah, I'm here. Can you hear me?
Yes, I can. All right.
Okay.
Welcome to both of you. We're on today for Ms. Giles' motion, pardon me, Mr. Connolly's motion for contempt related to visitations in early June, mid-June, and late June. And before we get going, I just want to make sure that the parties are aware that there was an original contempt motion filed by Mr. Connolly that alleged just those dates in June. And then later there was additional information that Mr. Connolly brought forward related to dates in July. And there's also, I think, some information about some later dates. So I just want you to know that there's the focus of the hearing is going to be on those dates in the initial contempt motion. So the June 7th through the 9th, June 14th through the 16th, and June 21st through the 23rd of June. So that comports because that's providing notice to everybody and an opportunity to be heard on those issues. Those other issues that have come up after the fact, that would have to be a separate motion for contempt. So I'll hear from Mr. Connolly first related to your motion, and then we'll hear from Ms. Giles.
Well, I mean, I just want to get my visits so that, you know, I missed like 4 or 5 different visits. I mean, I didn't see my kid for a good 4 or 5 months or even longer. So I'm just making sure that I get my time.
Okay. So it sounded like there was the Make-A-Wish trip that would happen the second week of June, the June 14th, 15th, 16th. Are you asking for a motion for contempt on that?
Yes, I am.
Okay. And then Ms. Giles in her response indicated that on the other dates, the June 7th through the 9th and June 21st through the 23rd, she said she was there at the exchange location and you never showed up. What's your response to that?
I contacted her and I had the wrong address to, you know, meet at, and she would not tell me where she was at. And actually, she wasn't even in town, and neither was my son during a couple of those. They were in Texas. So I don't know how she was there when she was in a different state.
The Texas trip, when was that?
I don't know exactly what dates they were, but
Okay. Okay. And then what's your position, Mr. Connolly, in response to the 2018 parenting plan? The parenting plan indicates that if there's a showing if you haven't provided proof of your SUD, substance use disorder treatment, and anger management classes, the order says that visits would end. There'd be no further visits. What's your response to that?
I'm pretty sure I filed it over a month ago.
Filed what?
My SUD and my anger management.
Okay. Do you know approximately the date you filed that? You said about a month ago?
Yeah, I would say it's been maybe even a month and a half. I couldn't tell you the exact date.
Okay, so possibly early August.
Yeah.
Let me do a quick search. I looked over the case pretty thoroughly and I didn't see that. So let me go back into July. And this is a declaration that you filed, correct? That you submitted?
Yeah. Yes, correct.
All right, let's see. So I've looked through from July 1st until present, and I am not seeing any submissions of compliance reports or SUD reports or evaluations or the like. So maybe you can double check your records, and if you have a specific date in which it shows that they were filed, you could point me to that.
Okay, 1 second. I'm getting it right now.
Okay. While you're looking for that, I'll hear from Ms. Giles and your response to the motion for contempt.
Yes, so his motion's asking for jail.
Well, why don't you go ahead and provide your argument, and then depending on my ruling, I can appoint counsel or not. So why don't you go ahead?
Okay, sure. So June 5th, we had court with you for his first contempt. And at that hearing, I had you were going to start the makeup visits for June, and then I had said to you, well, my son has his Make-A-Wish trip on the weekend that you were going to start it, and you said you didn't want to interfere with that. So that was already setting for it. So I don't think that should be heard for this one. And then, sorry, I'm trying to find all my paperwork. And then, okay, that's not it. And then as for the other visits, I had been going to the meeting place and he had no communication with me and he wasn't showing up. So I started taking pictures of where I was at, and that way I had it for, my personal evidence and stuff like that. And it's not my responsibility to make sure he has the correct copy of a parenting plan because he has the same access that I do.
Okay, so on June 7th, June 8th, and June 9th, can you tell me what happened on that date? What your response is to the motion for contempt?
On June 5th through the 8th, sorry, here's my papers. I have everything all written down in my stuff. On June 5th through the 8th, let me just read. So June 5th through the 8th, it was my understanding to follow the parenting plan like you had said to do. So if I was following the parenting plan, then because he hasn't filed compliance of anything about anger management treatment or anything like that, then he wouldn't have got visits.
So let me ask you a question related to that. It sounds like
Sure.
The parenting plan had been in place since 2018.
Correct.
And order was there. And I'm making an assumption, you can correct me if I'm wrong, that you had never pulled the trigger, if you will, on that particular provision. In other words, Mr. Connolly had not provided SUD evaluation or treatment compliance reports and had not supplied anger management class compliance up until that point. And at that point, because you'd been doing the exchanges, you'd been doing visitations, but up until that point, you hadn't exercised that particular provision. Is that accurate?
No. So I was actually following the parenting plan. There was a couple of times actually that we were getting along and hanging out, and he was like, oh, it's my weekend, but then he was drinking and I had to call the police on him, and they had to tell him, look, you don't get him. It's her discretion according to this. So I have been following it up until he had a baby he's going to be 2 in January.
I mean, did you ever say, look, we don't have the evaluations, we don't have the compliance reports.
Yes, I have said that.
You're not going to get visits today. Yes,
I have said that numerous times to him.
And then did he continue to exercise his visitation?
He didn't see him for a whole bunch of years, for a couple of years.
Okay, and so then the
because
visits,
of that situation.
And then the visit started again, and then,
Off and on. Mhm.
okay,
Because you know, I wanted my son to have a relationship with his little brother, right? So
okay. All right, so then on June 7th, 8th, and 9th,
actually on June 7th, 8th, and 9th, I did go to the agreed meeting place. I just wasn't taking pictures at that time. So June 7th, 21st, and 28th, I went to the correct meeting place. And he was never there. He had no communication with me.
okay. All right, thank you.
Mhm.
Mr. Connolly?
Yeah.
Anything you want me to know in reply to after hearing from Ms. Giles?
No, I mean, everything was in the text messages pretty much.
Okay. Okay, so at this point, there was the allegation is that on June 7th through the 9th, June 14th through the 16th, and June 21st to the 23rd, that no visitations occurred. And this is in part based on the 2018 parenting plan, and in part based on the contempt order that gave makeup visits on the second weekend of each month for Mr. Connolly. So on June 7th, the indication is that there were no visitation. Ms. Giles says that she was there and the visits just didn't happen. And Mr. Connolly indicated that he had the wrong address and that there wasn't communication from Ms. Giles. Then on June 14th through the 16th, that was the Make-A-Wish trip. The Make-A-Wish trip, my understanding is that you don't necessarily get to choose the particular dates that you want. It's a great service that that foundation provides for children with particular needs. And at the June 5th hearing, I indicated that I wasn't going to interfere with that. And that the child would go on that Make-A-Wish trip, notwithstanding the fact that it interfered with the father's visitation that one particular weekend. Then on June 21 through June 23rd, there's an indication from Ms. Giles that she was there present, ready for the exchange, and it didn't occur, and that Mr. Connolly was not present. And didn't really get a clear picture from Mr. Connolly of what his indication was, why he wasn't, what his position was, that if he was there or not there, or if he had rectified the address concern or the like. So as to the June 14th through the 16th, the Make-A-Wish trip, I'll make a finding of no contempt. There's no violation there. And also for the June 7th and also the June 21st, I think the evidence leans in the favor of Ms. Giles there, that she was present and that Mr. Connolly just wasn't present during that particular time. So I'll deny the motion for contempt. And I'll just just encouragement to Mr. Connolly regarding the compliance reports and the like. I don't know if you found those, but that would be really important for you to file that type of information. That way, it's a protection to you as far as your rights to have those visitations, because the 2018 plan does say that if there's not that compliance of proof of those SUD treatment records and also the completion of the anger management classes, then one of the remedies in the parenting plan is no visitation. So I'd encourage you to get that information in, and then that protects your rights to have visitation.
Yeah, I actually sent a picture of them to her the day I filed them, but I guess I'll refile them. I mean, that might
Yeah.
help.
Yeah, if you could, please, I think that would be helpful to avoid any confusion in the future. So I'm going to, as far as the motion, I'm just going to draft just a brief hand order that's denying the motion for contempt. So give me just one moment.
I have a question too.
Go ahead.
Other than the makeup visits that you gave him for August, I think October, the makeup visits and the first contempt.
Right.
If I'm following the parenting plan, then he doesn't get visits unless it's those makeup visits. Am I correct or am I wrong? If I'm going by the parenting plan, because I don't have anything showing that he's done what he's supposed to do.
So I'm not in the habit of giving legal advice or prospective rulings about what may or may not happen in the future. I think everybody has read the parenting plan. It's pretty clear on its face to what happens if that information is not provided.
Thank you.
This, in response to the denial, the motion for contempt, this is what the order says. Mr. Connolly's motion for contempt for missed visits on June 7th through the 9th, June 14th through the 16th, and June 21st through the 23rd of 2024 is hereby denied. So I signed off on that, and that'll conclude the matter for today. So thanks to the parties. That'll conclude it.
Thank you.
Thank you.
All right, Ms. Lytle, I'm not hearing anything from you, so if you're there, make sure you're unmuted. And I'll ask if Thomas York is on the line. Mr. York? All right, not hearing a response there. It looks like Ms. Russell is present, representing the Division of Child Support. Ms. Russell, I just want to double check with you. As far as service of the motion and the proposed child support orders on the parents, did you provide proof of service? Because when I looked in the file, I didn't see proof of service.
I'm
I
not
think-
seeing it in my file.
Yeah, I think I saw a docket
It's
notice.
really unusual.
Yeah, I saw a docket notice, but I didn't see the actual declaration of service of all the underlying paperwork. So I guess unless you have that document there, the proof of service, I think we would just be striking the matter and then you could renote it with proper service.
Indeed, Your Honor. Thank you kindly.
Okay. All right, very good. So we'll go ahead and strike that matter and it can be renoted. All right, looks like the parties are present. We have Mr. Warmdahl present, and then Ms. Mierendorf is also present, and we should have Ms. Karen Lawrence who's on the line. Ms. Lawrence, can you hear me okay?
Thank you, Your Honor.
All right, very good. Okay, we're on today for a review of the Guardian Ad Litem report, and I'll first check with the parties. Mr. Warmdahl, did you receive a copy of the Guardian Ad Litem report?
I did.
Okay, and Ms. Mierendorf, did you get a copy?
I'm sorry, what?
Oh, Ms. Karen Lawrence, the Guardian Ad Litem, drafted a report.
Yes, Your Honor.
Did you receive a copy of that?
Yes.
Okay. All right. So I've reviewed that, and the Guardian Ad Litem makes some recommendations of what she feels would be in the best interest of the children. So there's a couple ways to approach this. One, I've gone back and forth on this, but I think I'm leaning more towards this at this point. That when a Guardian Ad Litem makes recommendations for parenting time, that's a bit of information that I think is important to consider. Then I also think it's important to consider what your particular input is related to those recommendations. And so I think everybody here has read Ms. Lawrence's report, and I appreciate her efforts in preparing that. And that I also think that at this point, it would be premature to enact that parenting plan without a particular motion from one party, because one party may say, I think that's a great idea. The other party may think that's a terrible idea, and you'd each have your respective opinions expressed. And then we'd come to court. I would consider the Guardian Ad Litem report. I consider Mr. Warmdahl's viewpoint, Ms. Mierendorf's viewpoint, and then make a decision on that particular motion that one party has brought before the court. So that's kind of where I'm at today. I mean, does that make sense? Because sometimes in the past, what I've done, the Guardian Ad Litem would make a recommendation, and then we'd come here, and then you would argue and say, this is what I want for parenting plan, and then I'd make a ruling today. I don't think that's the best form of doing it, because I've heard the Guardian Ad Litem's voice, and I know we've been here before in the past, but I think it's better that if a party has looked at that report and either likes it or doesn't like it, either party could file a motion asking for a particular parenting plan and supply declarations and your personal perspectives and have opportunity to know what the other party's saying and then reply to what they're saying. So it's a long way for me to say that if the report has been received, and then if either party wants to take action and have that either enacted or not enacted, then you'd file a motion and say, please, let's put it in place, or let's please don't put it into place. Mr. Warmdahl, do you have any questions on that explanation?
So I need to file a motion to not have this put in place.
If that's your desire, correct?
It very conflicts my schedule. I work out of town. I'm down by Milwaukee right now, and I work 6 days a week. So if she gets in while I'm at work, I already qualify for a motel down there, but I have a family of 4 at home. So I just take drive time and gas money to see my family every day. And it would be a lot to take him every single morning and then pick him up every single night. And then she gets Sunday on top of it. Like, why would I have custody at that point?
Yeah, so all those things that you're saying about the drive time and how that interplays with the Guardian Ad Litem report, those would be things that you would write in your motion and your declarations and support that. And then Ms. Mierendorf would have an opportunity to respond to that. It gives me some time to sit with it, think about it, not be here in kind of the pressured environment of the courtroom. So if you want to do that, you could bring the motion. And then Ms. Mierendorf, do you have any questions about what I explained about the Guardian Ad Litem report and motions?
Yes. in the mornings, I can come right to him. Like all he has to do is have him outside. I can be there. Like anytime, any day, it does not matter. I'll get up at 2 o'clock in the morning to do it.
Okay.
I will do anything for my son.
So it's in similar vein, you have your ideas of what about the guardian ad litem's recommendations. And so it sounds like that you're in favor of that. So what I'd encourage both parties to do, or whoever wants to do it, you could file a motion for a parenting plan or adoption of the JL recommendations or non-adoption of the JL recommendations. And then we could note it up and have it heard for hearing. So Ms. Lawrence, do you have any grave concerns about that approach as far as timing or well-being of the child in the interim?
No, I think we need to hear from both parents on that. I know that Robert does have issues with it. And I don't think that Alexis does, but I haven't talked to either one of them about the recommendations specifically. Just gave them my report and here we are. So I think it's a good idea to hear from both of them and have them both provide a motion or whatever they want to do.
Okay. All right. Thanks. So at this point, the guardian ad litem recommendations are just that, recommendations. It's going to need one of you to bring the motion to the court to either deny those recommendations or to implement those recommendations. So one of you or both would need to file a motion, serve the other party, have your declarations supplied to each other, file it with the court, and have it noted for a hearing, and then we can make a decision on it. Any questions on that, Mr. Warmdahl?
Your Honor, I would remind them that they need to serve me with that as well.
Thank you. That's a good reminder, Mr. Warmdahl.
So it's a motion for another parenting plan, or what is?
Yeah, there's a parenting plan in place. It's that short one, the handwritten one that I think that I had written from June 26, 2024. It'd be a motion to modify that parenting plan.
Okay.
So, Ms. Merendorf, do you have any questions?
I don't, but I do have a concern. Mr. Orno's girlfriend has been nonstop harassing me. Any chance she gets, my son was a victim, and I was too, but any chance she gets, oh my God, I constantly called a baby killer. I wasn't home.
So let me ask you, just with regard to your concerns related to Mr. Warmdahl's significant other, that's part of the recommendations from the guardian ad litem. She addresses that. So is that something that you think you could either bring in your motion to modify a parenting plan? Your other option also, if you feel if it's out of hand, you could file a motion or a petition for an anti-harassment order.
I have filed anti-harassment.
Okay. All right. So I think those are the two remedies if a person's in your position seeking some type of relief from that. Okay. Any final questions, Mr. Warmdahl?
Do you have anything to say about that at all? Or should I?
We're not talking about it today.
Yes, sir.
Yeah. So if that can be addressed in any motion that the parties bring forward, and it also could be addressed through an anti-harassment petition. Any final questions, Ms. Merendorf?
That was it.
Okay. Ms. Lawrence?
That's all, Your Honor.
Okay. So I'll leave it in the parties' hands to either, push for the adoption of the guardian ad litem recommendations or push against the recommendations of the guardian ad litem. So you'll need to file something and get copies to everybody, including the guardian ad litem. Okay, I think we're done for today. Thank you.
Thank you.
Thank you, Your Honor.
Make sure you're unmuted and state your name. We'll look through the participant list and see if Damon Woodhams is present. Don't see anybody with any D. I'm looking in the Ds for Damon, not seeing that. And then Woodhams, I'm looking in the W area. Don't see any Ws. We do have, you're Samantha Woodhams?
Correct.
Is it Woodhams?
Yes, Woodhams.
Okay, all right, thanks. So this is I believe, if I'm not mistaken, a motion brought by Mr. Woodhams related to a parenting plan and child support. He's not here. And I didn't show that a proof of service that you had been served all the documents. Did you get the proof of?
I have not gotten the actual proof of service,
Okay.
so.
Yeah, without that, we really can't move forward. So without his presence here, and I'll just double check again to see if he's here. Damon Woodhams, if you're on the line, please unmute and state your name. I did a search under his name, first and last. There's no match, and he's not in the courtroom today. So I'm going to strike the hearing. That we can't move forward without that proof of service.
Okay.
Okay. Any
Thank you.
questions?
No, I was just gonna ask I was still seeking legal aid and to go forward, but.
Okay. All righty. Thanks.
Thank you.
Looks like Mr. Jenkins is making his way up. Good morning, Mr. Jenkins.
Good morning.
All right, I'll ask if Amy Wright is on the line or in the courtroom. Amy Wright. No movement in the courtroom.
I'm here.
Okay, Ms. Wright, can you hear me okay?
Yes.
All right, very good. All right, so we have Mr. Jenkins in the courtroom, and just make sure that your microphone is close to your mouth. Looks like you're well positioned there. Thank you.
Okay.
And we're on today, it looks like, for a motion that Mr. Jenkins brought forward to set mediation. One thing I wanted to check first with Mr. Jenkins, did you file a, let's see. Okay, looks like you did. You filed the declaration of service, and that was done. And it looks like it was served on September 11th, correct?
Yes, I believe so.
All right, okay. And then Ms. Wright, did you get a copy of those documents as far as the motion to set the matter for mandatory mediation?
Yes.
Okay. And did you file anything in response?
No.
Are you in favor or objecting to the requested mediation order?
In favor.
Okay. And Mr. Jenkins, I think that you provided a proposed order transferring the case to mandatory mediation.
Yeah.
Is that something you still want?
Yes, I want to go to mediation. That way we can either agree or disagree with our plan. It's pretty close already, so
Okay.
hopefully it goes really easy.
Okay. And then Ms. Wright, did you receive a copy of the proposed order transferring the case to mandatory mediation?
Yes.
And any concerns with it?
No.
Okay. So it sounds like the parties are in agreement regarding that particular order. So I'm going to sign off on it and require that the parties participate in that mandatory mediation. And hopefully that goes well for both of you. Hopefully you're able to do some give and take and come to resolution. So I've signed off on that. The issue that will be mediated will be the parenting plan. And do the parties know where to go to get that set up?
No, I do not. That was my next question.
Sure. In the proposed order, it says that the copy of this mediation will be given to the Community Mediation Center. So there's a couple different options here. So let me just pull it up here. So there's one that I can give you, and then certainly the parties are welcome to choose other mediation services. This is just one that I'm aware of. It's called the Community Mediation Center. It's located on Commerce. So their website is communitymediationcenters.org, or if you just type in Community Mediation Center Longview, it'll pull up and it'll give you their website. It has a phone number. I can give that to you right now if you want to jot it down, or you can just check the website.
I'll check online.
Okay.
Yeah.
All right. So basically, both parties would make contact with them, provide your contact information, and they would talk to you about finances, about what the cost is going to be. They have some different sliding scales depending on income levels, and then they would set up the time and dates and give you kind of the marching orders of what information they need, how to prepare, and the like.
Okay.
So it sounds like you're comfortable with that, Mr. Jenkins. Ms. Wright, do you have any questions?
No.
Okay, so what I would do is just encourage both parties to reach out to that group or to another of your choosing, and then get that going. And then good luck to you in your mediation.
All right. Thank you.
Good, thanks. All right,
Thank you.
That'll conclude the hearing. 608 is the cause number. All right, looks like both parties are present. I'll give you a moment to get settled. Okay, just to confirm, you're Miss Emily Anglin, is that correct?
Yes.
Okay, and you're Mr. Eric Dorland?
Yes.
Okay. And is it Dorland or Dorland?
Dorland.
Dorland. Okay, can I just do it fast? Okay. All right, so this is Mr. Dorland's motion to terminate the restraining order that was, it was entered on July 22nd of 2024. So I've read the separate pleadings that each party has submitted, and I reviewed the respective parenting plan and the like. So I'll hear first from Mr. Dorland, and then I'll hear from Ms. Anglin.
Just on the subject alone of the restraining order or everything?
On the motion to terminate the restraining order. That's what I see that we're noted up for today.
Okay.
And that were you under a different impression?
When I spoke to, I forget the judge's name last visit.
Thatcher.
I got it in relatively quickly for the motion of just adjusting that temporary parenting plan, because I wasn't given, it was served by mail, never notified or asked for my address. It was sent to my dad, and it was supposed to be about 24 days if served by mail, to my
Mhm.
understanding, and it only got 20 or 21 days.
And that's
So-
why it was set over to today.
Yes, that,
Okay.
well, that's why, yeah, because I told him I'm working, and so taking days off every time, if we can combine some of it, that would be good, so I don't lose, it's hard on work. Like right now, we're a roofing company, so our crew's shorthanded.
Right, right. So, it looks like you were here, was it on August 28th that you were here last in front of Judge Basher? Does that sound about right?
I believe so, yes.
Okay. So, so at that time, the court extended the temporary restraining order to allow Mr. Dorland to file a response to that. And you expressed concern at that time about coming back to a court and missing work. You were concerned about the proper notice, which you mentioned here today. And then that Ms. England responded that she's followed all the necessary steps. And it says court responds, issue to be raised and motion to modify. So let me ask then there, well, you see here on September 5th, Mr. Dorland filed the motion to modify a temporary family law order. So in that, there's some boxes that you can check and say, these are the things I want the court to look at. These are my concerns. And so the only box that was marked was related to the restraining order. It says the court already sent a restraining order on July 22nd, 2024. I asked the court to remove or terminate this restraining order. And then, so then as far as other temporary orders or requests related to the children, other than that restraining order, it says no request. And so that's why I was under the impression that we're here just for the restraining order.
Okay, for clarification, because she did have me check the boxes on the family law motion that wanted addressed, and it was turned in that day with everything else. So I don't know which, is that the docket? Is that what that is?
So I'm looking at your motion that was filed on September 5th, and it's titled Motion for Temporary Family Law Order and Restraining Order. So on page 2, normally I'll see if a person is interested in changing a parenting plan, it'll say, yeah, this involves the children. But it says under children, under that title, it says no request.
Oh, okay, that was just because the restraining order didn't have anything to do with the children. That's the only reason why I didn't check that, so maybe I misread that.
Yeah, and then the other paragraph that could apply is care and safety of the children. Check all that apply, and it says approve the parenting plan proposed by me. That's not checked, but the box that says no request says it is marked. So that's just another indication that told me that we're not talking about parenting plan here. We're just talking about the restraining order.
Okay, I apologize. I did I think there was a form where it said what forms you wanted to address. I don't know. I had her help me with it, so I'm not sure.
Yeah, it's difficult if you don't do this on a regular basis. It's kind of difficult to make sure everything's just right. I just want to make sure that there's a portion in that your motion to modify where you kind of some handwritten information of why you're asking for what you're asking for, and the focus there is that you've never harassed her, you've no history of violence, and all those things, and it all relates, at least in my mind, to the immediate restraining order. So again, that just gave me further confirmation that that's what we're talking about today. So
well, that was also in response. I'm sorry, am I interrupting? I apologize.
No, go ahead.
Okay, that I'm not sure where it's at because I only put out a separate form, so where you're reading which paragraph, but some of that is kind of directly pertained as well to the allegations of like issues as to why, for one, in however many years I've never needed supervised anything, and then all of a sudden when I moved back after going to the pre-apprenticeship program, getting in the central job after COVID, all that stuff, now I need supervision. I raised my children too before divorce. I had them without supervision before I left. The only thing that's changed is, and see, I would have been open to a little bit of a gradual, getting comfortable again, stuff like that. Like I tried for communication. I was always really busy, things like that. A lot of kind of sent around the loop a little bit, but I don't, for one, I want to clarify, I don't want to force Sienna, my older one that had the harder time, but I want her to have the option on, the weekends of my visitation. I know my little one wants to come. I just had her Saturday baking together. Like, I have.
So let me, if you mind, I apologize for interrupting.
No.
Just because I'm still kind of just focused on what we're going to talk about here today. So I read that there was going to be an indication. I mean, you filed a declaration in support of a parenting plan. What I didn't see is that you submitted a parenting plan. I saw that you submitted, and then Ms. Anglin filed a response to your declaration in support of the parenting plan. But then I don't have what you want as far as a parenting plan. So that gave me further indication that we're just talking about the restraining order today. So, and I recognize time off from work is a big deal. That's cash out of pockets, but at least I think kind of in fairness to everybody here that the restraining order, the motion to terminate, that's what we're going to talk about here today. And if you want to talk about the parenting plan, which I think you do, you'd need to submit a proposed parenting plan of what you feel like the modification or change to that parenting plan should be. Because at this point, I don't have that.
Yeah, it's filed, so that's why I'm just curious.
Is it?
I don't know what we're looking at. Because I remember checking off, she, would tab to mark what I was supposed to check off, because I had like 7 copies, or 3 copies of like 7 different, there were 3 different stapled. There was like a form 139 and 140, I believe. So it did have like what I proposed, which was every other weekend.
Do you know when you filed that?
I believe I came back maybe a day after or 2, because there were some things that I need to adjust, but I ended up finding actually, I believe all of it get filed together because I took with me and adjusted. But yeah, it was all, she probably has the copy.
I have the paperwork.
I don't.
Yeah,
I don't.
That's on there.
So
And then I responded to it and then.
yeah, I saw your response, but I didn't see his proposed parenting plan.
Yeah, she got the card. They gave me ones to serve to her that I gave to my dad, and then I had to make ones for them as well.
Yeah, I think that's great. So you two know what the potential proposed orders are, but
right. No,
I don't have it, so I apologize. So
no, it's okay.
So I think what we're going to do, we're just going to narrow and we're going to keep the motion set to the motion to terminate the restraining order. So that'll be our focus here today.
Okay.
So I'll hear first from Mr. Dorland. It's your motion, then we'll hear from Ms. Anglin.
Well, basically what had happened was a day or two, I'm not sure which day, she decided to block communication. I was aware that my dad was appointed to supervise visits from that was so it was like that first Saturday, and the stipulations were unless there's vacation or games, which they always have those. So I was checking because I wasn't being informed of schedules and things like that. And so come Friday before that Saturday, trying to text about like, what's the plan with the kids? Are they, because at that point I wasn't getting any communication directly. I was told to, I figured it out on my own, you figure it out. Well, I didn't even know the name of the teams she had signed them up for. If you're signing them up, how am I going to figure that out? And so anyways, when I blocked text, the only time I've ever stopped by, I knocked on the door, stepped back from the door, 10, 15 feet back. And she sent out, I believe it was Sienna first, my 15-year-old daughter. And she's upset, you're not supposed to be. I said, look, I'm not here to deal with you guys. This is I need communication to figure out what's going on. And I said, can you just send your mom or your stepdad out? And then, then Logan came out and was basically like, this isn't your day. You're not supposed to be here. I said, I'm not trying to be here. I need some.
Is Logan the older?
Yeah.
He's 18.
Yeah.
Okay.
And so anyways, I waited a few minutes, didn't discuss much with them directly. I just told them that it was, this isn't supposed to be with you guys. Like, I'm sorry, I'm trying to figure out when I get my daughters or if I do. Ended up leaving. That was that. Now, when we came back last, it's been clarified that my dad will be a mediator. But as far as any issues in the history of things, I'm not, we had issues. That's why we got divorced, but never like violence or things like that or anything. So these allegations are completely like unwarranted. I don't go stop by her house, nor have I ever. I've respected their family. That was the only time is when you cut off communication the day before. I'm trying to figure out, like, am I going to see my kids? I need to know, and I think that was kind of let's make Eric wait as long as we can and not know what's going on as much as we can agenda. And I didn't raise my voice. I didn't get upset and I left. It was a few minutes.
And this in context, you had moved back from California at this point?
Yeah. I actually got here the day after that court date on that temporary immediate parenting plan change that I wasn't aware of.
Okay. All right. The day after. Okay. Okay. And then your indication was that you had tried to reach out or communicate via text or phone and didn't get any return
Correct.
message. Okay. All right. Thank you. Ms. Anglin?
So June 8th, he came into town for our son's graduation party, and I let him take the girls afterwards, and he left them alone in Portland. Well, my daughter said that he said.
So that was on June 8th or 18th?
8th.
8th, thanks.
My daughter told me that he said, we're going to go get drinks, him and his girlfriend. So he left my 2 daughters alone. in Portland. So that was my final straw. And so I decided to change the parenting plan. So he couldn't do that anymore because he has a history of leaving them alone. When he doesn't get what he wants, he gets aggressive. He has a history of that. I've known it for 20 years. So I told his dad that I was going to be having paperwork sent. I asked him if he could be the mediator. And if he didn't want to do it, I could get somebody through the court. He said no.
That's Gary you're
Yes.
talking about? Okay.
He said, no, I'll do it. He says he doesn't have a history of being violent, but there have been holes punched in walls. You know, I'm not making things up. So when he showed up at my house, I got like this. I got panicky. My kids saw me like that. And so they said they would try and get him to just leave. So I didn't force them to go out there. I didn't ask them to go out there.
Did you receive any communication from Mr. Dorland before he arrived at the house?
Before that, after he found out that I was filing this paperwork, his father let him know in June, I think it was 20 something. I started getting text message after text message, call after call, and I just decided, you know, he has the ability to get this paperwork and see what the parenting plan is instead of harassing me to let him know what's going on. So instead of doing that, he showed up at my house.
So
And he says it was a
he'd been texting you a lot?
Yes,
And
so that's
did
why I blocked him.
So you blocked him?
And Gary had already agreed to be the mediator.
Okay.
May I respond when she's finished?
Yeah, I'll give her full
Okay.
opportunity, but just remember what you want to say. So this was in context of the new parenting plan that had been put in place.
Yeah.
Okay. So you'd blocked him, and then so you didn't receive any of the messages that he had sent in prior to him showing up at the house.
I don't know what he texted after I blocked him. He's still blocked.
Okay. So then go ahead and tell me next what happened.
And when he showed up at my house, it wasn't like calm conversations with my children on the porch. There was some yelling. My daughter was in tears. I had 911 dialed on my phone when he turned around and finally walked to his truck to leave. That was Friday the 19th. I went Monday morning and I got a restraining order. We have a mediator. There's no need for him to contact me, especially coming to my home.
Okay. And then how long do you think that whole episode lasted at the doors on the porch?
It felt like forever, but I'm sure it was only like 10 minutes.
Okay. So you said there was some yelling. Who did you hear that was yelling?
Both my children. I heard my son say, "I don't care about your new girlfriend." I heard my daughter say, "What is wrong with you?" as she walked back through the door in our house, crying.
Okay. Did you hear anybody else yell?
No.
Okay. In particular, did you hear Mr. Dorland yell?
No.
Okay. Other information you think I should be aware of related to the request to terminate?
I don't have anything else.
Okay. All right. Thank you, Ms. Anglin. Mr. Dorland, response?
Okay, I would like to just respond to a few of the things. The incident with Portland, my daughter's 15 and Marley is 8. We went thrifting, then we drove all the way downtown, walked around. We went to the little mall. They wanted to go to Raising Cane's, say anything about a drink. I wanted to get quesadillas. There's a Mexican place just outside the food court across. I walked Sienna and Marley to the line. I knew they had about a 10-minute line. I said, you don't go anywhere. If you need to go, you can go to the bathroom, text me. I want to get some, there's a place that I go. That's it. Grab those while they got theirs. I was back by the time they got their food. If that was a problem in bad judgment, honestly, that's something you could say like, hey, I'm not comfortable with that. I would adjust it. I don't think that's that extreme. I know they've left in situations that I don't necessarily agree with or disagree. Some of them maybe not, but whatever. I don't leave my children. There was one time, like when she's talking about holes in the wall, I'm 21 years old. Also, there was one hole in our wall ever from punching immature being a kid, but none of that. There has been violence from her and she ran my car into the garage and got a DUI. Like if we're talking about 15, 19 years ago of these incidents, she has not known me for 20 years because she hasn't known me for the last 6, I can promise you. Now, I am not saying that there's never been struggles and stuff on both ends, but I think normal things when you're going through a terminating relationship. Nothing, I've never threatened. I don't cuss. I've never put profane language in text. And when we're saying a lot of texts, 2 or 3 consecutive texts about realizing that she didn't ask me for my address, but she put that in court. Come to find out, she explained she asked for the invitation that I wanted of Logan's graduation. I said, because I was going to be there, just go ahead and give it to my dad. Had I have known I was being served with court documents, yes, I would have had that sent to my address because I want to know what's going on. And she said that she didn't do that because she was worried I was going to freak out. Now, I don't have anything that's happened where I've went and showed up and freaked out. I was not told my dad was the mediator. I was told he was for supervised visits. We had been communicating up until, I think Wednesday was the last text I sent, kind of responding like, why did you, I'm going to bring up that you claim that I refused to give you my address because you know that that's not true. And I was upset, but not anything in a tone of harassment or threat or anything like that. I'm 39 years old. I love my kids. I just want time with my girls. I don't want to interfere with their life. I don't. Like, that's fine. You do you. I've never stopped by unannounced. I've never made a scene in public at games. I walk by, I spend time to watch my kids. Our youngest comes over to me. I don't have issues like this. I just want to work my job, have my family. And that's really it. So this seems very unnecessary. And then trying to take circumstances and skew them. Notice how she couldn't state that you heard me raise my voice. Yes, there was some. Now I spend 6 days with my son a week, by the way. We go to the gym. He calls me to come over and have dinner right now because he's 18 and can't be kept from me. And I do know I'm not a perfect parent, but I do love my children. And I do have complete self-control in my choices and my movements. I'm not 22, but we haven't been for almost 20 years, but never have I ever put my hands on anybody like that or anything. It's just, I'm sure there was, immature actions and things, but that's a long time ago. And why from 4 years of me going through this apprenticeship program and becoming a journeyman lineman, now I need supervised visits and restraining. This is excessive. I haven't bothered her with, I've let my dad be a mediator since then. And that's fine if you want to do that. All of this is very unnecessary to me, but whatever, I don't really care. I just want to have my kids, and be able to go to their games and stuff like that and get their schedules. Because now that my dad has been a mediator, she willingly lets me know that through my dad schedules. So if that works for you, great. I just want the information,
Okay. Thank you. Ms. Anglin, what time of the day did that occurrence on July 15th help when Mr. Borland came to the house? So,
I don't remember.
Approximate time frame, morning, afternoon, evening.
It was a Friday and the kids were all home, so I'm assuming it was after school sometime.
Cool. Okay. It wasn't dark outside. Okay. All right. Thanks. Okay. So here there's a motion to terminate the restraining order. What I do know is that there's a temporary parenting plan that was put in place as of July 10th of this year. I know that there's some concerns, at least from Mr. Dorland's perspective, as far as service and the like. When the court held that hearing, the court reviewed the particular information related to service and the like and found it was valid. There's valid service, and there wasn't. On that particular date, Mr. Dorland wasn't present, so the court signed off on that temporary parenting plan. So I recognize that Mr. Dorland. I think I'm reading between the lines. He would say that that's unjust. It's not fair. Blah blah blah. And Ms. Anglin, and from her vantage point, thinks that's perfectly reasonable because notice was given. So that's going to be a separate issue. The parties can litigate that or figure that out. But at this point, that's the temporary parenting plan that's in place, and that's where it has the restrictions as far as I think it's the first and third Saturdays, if not conflicting with activities. And Mr. Dorland, Gary, would be the one that provides the supervision. It also goes on to say that as far as the exchange location, it's basically it's going to be at Mr. Gary Dorland's home, and then Ms. Anglin would be doing the transport to and from. Basically, she drops the kids off and then picks the kids up after the visit happens at Mr. Dorland's house. So that arrangement at this point under that parenting plan limits to a large degree the contact between the parties as far as physical presence. It limits it pretty significantly, and it also has the benefit of the buffer of a third party being present, Mr. Gary Dorland. So the motion to terminate this, I recognize Ms. Anglin was pretty shook up by Mr. Dorland showing up at her house after he'd been living in California for a number of years and working and getting the apprenticeship and the like. So I think that startled her. And I think it's important to note also that, I think that, when asked Ms. England, if you heard yelling, both kids raised their voices at certain points, but she didn't hear Mr. Dorland yelling during that time frame. I think that's important. I don't think it's, conclusive of the total nature of that particular interaction, but it gives kind of a flavor. I recognize people can be really intense and not raise their voice, and yet there still wasn't the raising of the voice. 911 was not called. Mr. Dorland did leave. I'm going to terminate the restraining order at this point. The parties will abide by the temporary parenting plan. And if any party wants to address that parenting plan, they can file a motion related to that. And I recognize that's where we talked about earlier, what our focus here was today was the restraining order. So if the parties are seeking any type of modification of that, you'd have to file a particular motion there's a petition to modify has been filed by Ms. England previously, which led to the new parenting plan being put in place. And then again, I don't know what Mr. Dorland wants as far as the parenting plan, because I haven't seen it. So if you want that to be addressed, then you'd have to file that, give Ms. England a copy of it, file it with the court, and then we can have a hearing on that. So, but I'm terminating the restraining order at this point.
Okay, because she does have it, because I know that we served it, and I know I sent it in. What should I do? Just check with?
You can check with the clerk's office. I'm human, I make mistakes, but I've looked at it pretty carefully and I don't see it in here.
Yeah, no.
I did a keyword search. I typed in parenting, I did parent, and it doesn't pull up. So
neither
it'd have to be
forms, the
refiled.
139, or I think it was like 140 or something, neither forms show.
140?
Is that correct? I think it's 139 and 140.
What does that number reference?
Can I look? I'm sorry.
Oh, you're talking about the forms that are found on the webpage, I think.
Yeah, because those are the two, and I think she has both of them, but I'll just check and follow through with them. I'm sure it buys me.
Okay, well, I talked about mistakes. So that's what you're talking about. There's your proposed parenting plan. It's not filed. I have a hard copy of it, but I didn't. So normally this is the way I work, is that if something's filed, I read it. And then if there's proposed orders based on that, I'll look at those. So my little process of reading things that have been filed that would prompt me to look at the proposed orders wasn't there because it wasn't filed. So that's on me. So your parenting plan is here, but it's not filed with the court. So what I'd encourage you to do is to file that, and I can give it back to you if you want.
Sure.
So and the clerk can give you that. And then this one also pertains to that. There's that separate temporary family law order, and that could also be filed. Okay.
I had filed I think it was 18-page declaration in response.
Yep, I see that. So I reviewed that in preparation for today. So the temporary restraining order, it ends today, but the parents are required to follow that temporary parenting plan that's in place. Okay. So I won't set a date at this particular time. That particular proposed order have to be filed, and then that motion, I think it's your family law order. Just those proposed orders would have to be filed, and then you could note it up for a docket notice.
Okay. Yeah, I guess I'll just ask them, will they be able to guide me on what I didn't do correctly, maybe?
You can check with courthouse facilitator. They're a member of the clerk's office. They can give you some guidance of what needs to be filed or has been filed, or if everything's okay.
Okay.
All right. That'll conclude today's hearing. Thank you. Madam Clerk, is there a particular form that's mandated for the termination of restraining order?
I am, Your Honor.
Okay, welcome to you, Mr. Kamba. I'll ask if Desiree Kamba is on the line. Desiree Kamba, if you're here, state your name. Okay, Ms. Kamba, I can't hear you, so if you are speaking, Desiree Kamba, make sure that you're unmuted and again, state your name, Desiree Kamba. We're not hearing a response. There's no movement in the courtroom, so she's not here in the courtroom. This is Mr. Kamba's motion for contempt. Service was mailed on August 27th to an alternate address, so service is proper upon Ms. Kamba. And this is related to a request for contempt for withholding of the child based on the June 2023 parenting plan, and that you're asking for costs of the $5,000 of private investigator fees. Can I just ask you, I'm inclined to grant you the contempt, Mr. Kamba. I wanted to ask you about the private investigator fees. Do you have any documentation related to that, as invoices or payments of anything of that nature?
He did send me a way to pay online. I'd have to go to my bank and get a screenshot of the charge.
Mhm.
And it wasn't $5,000 for it. It was, I believe it was like $150 or $160. But all the other fees for like my process server and everything, um, she still has to get paid. You know, it's taken a lot of work.
Okay,
So,
so the private investigator say was about 150, 160.
mhm.
And then your process server fees, what of those, what total or what amount is that?
um, well, it would be the rest. So about $4,000.
And do you have invoices related to that? Because generally, you know, I'm not averse to awarding those fees. I just need some support or foundation for it.
I don't have an invoice for it, no. My process server, she is here, in the court,
Oh, she's in the car.
waiting also, and, so,
Oh, is she on Zoom? Did you say?
yes,
Okay, what's
yes.
her name?
Sabrina Clements.
Okay, Ms. Clements, are you on the line?
Yes, I'm here.
Ms. Clements, have you submitted an invoice for payment for your process service fees?
Not as of yet, but I can do an itemized list of that. It's just gonna take a little bit of time because I've been doing this since June of 23.
Okay.
When he lost the attorney, I picked up doing all documents and all services.
Do you have an estimate of what your fees are at this point?
Um, I would say probably about with my time of service and trying to research where was in our area, um, probably about at least $3,000 with fees and time and drive time and all of that stuff.
Okay. Okay, so Mr. Kamba, I've read over, you know, I'm familiar with your case and your motion and the concerns that you have related to not seeing your son for a significant period of time. So I'm granting your motion for contempt that the order of June 2nd, 2023 was not followed by Ms. Kamba in that she didn't follow the parenting time schedule and other parts of the custody order as you described in your motion for contempt. Making a finding that there is bad faith, that she's left the child apparently out of state, not allowing any visitation with father. And the issue as of the fees and the like I said, I'm inclined to grant that, but I need some type of documentation related to that. So what I'm putting there on the order, I'm putting reserved. Reserve means basically you can, if you bring back that documentation, then we can take a fresh look at it. So I'm just putting reserved upon a showing of documentation. I'm just writing that in the order. And I'm just going to make clear that it's not lawyer fees we're talking about. We're talking about a private investigator and process server. So make that finding of contempt. Then in your proposed order, Mr. Campbell, you asked for 1,000 days in jail in the Calais County Jail. Is that correct?
Yes, and the reason being is she's choosing to take this time to do the most to keep him from me. Since it just yes.
So we've talked about this before, Mr. Kamba, the difficulty of her not being in the state and the child being with her. What I've traditionally have seen, and this is where I've encouraged you to reach out for legal assistance from an attorney. What I've seen in the past when a parent absconds or takes a child out of state in contravention or against a parenting plan court order, there's a long series of efforts that need to go into that to get a warrant issued and make it an interstate extraditable warrant. to get law enforcement involved. It's a fairly involved process. And that's why I encourage you again to seek out legal counsel to assist you in that process. Because at this point, yeah, I can order jail time, but it's not effectuated until she's here in front of the court. So I'm not going to order the jail time. I'm going to indicate that jail time is reserved. But again, just strongly encourage you to seek out legal counsel from an attorney to assist you in the process, because the ultimate goal, I think, is that if she's out of state, as you indicate, and she's withholding the child, then to get her back, if she's not going to come back willingly, then law enforcement would have to get involved and arrest her and bring her back along with the child. So that's an involved process, and it's takes some experience to get it and get it done right. So I'm signing off on the contempt order. And then again, I just encourage you to reach out to counsel to assist you with the next steps in order to get her here and the child back. So go ahead.
From my understanding was I was just waiting for the prosecutor to look at the paperwork and put the warrant out for her arrest. And
yeah, that's another option, that a prosecutor could file a custodial interference charge and then seek a warrant, extraditable warrant. That's one option. There's a civil aspect too, that if you wanted to go that route, that's where my encouragement comes on that end.
yeah, I already she's already have that as far as parental interference. So what I was saying was I was just waiting for the prosecuting attorney to re-put that.
Okay.
Unfortunately, they're on vacation until sometime mid-October. Tried contacting the prosecuting attorney that is currently handling, where the other person's missing out on because they're on vacation. And so I was wondering if that's all I'd be needing, because I mean, she's in contempt. There's a warrant for arrest. I found her address. Is there, like, because I already contacted local police, so they're supposed to be contacting Tucson police
okay,
to help with that. So
yeah, so at this point, I think those are your two options. You can seek the assistance through a particular prosecution, or you can follow the suggestion of hiring private counsel to get some type of civil extraditable warrant. So at this point, I'll let you work through that. I've signed off on the contempt order, and that'll be filed. If you need a copy of it, you can check with the clerk's office. So that'll conclude the hearing for today. Thank you.
okay, thank you, Your Honor.
Next, I have Nicole. All right, so we have your Nicole. How do you pronounce the last name?
His last name is Ussery. My last name is Elam.
Elam? Okay. So we have Nicole Elam, and then we have Jonathan Ussery. Okay, great. Okay, so we're here on Ms. Elam's motion for an immediate restraining order. It looks like there was a temporary restraining order that was entered as a result thereafter. And then you also filed a motion for a temporary family law order, including a restraining order pertaining to the three children, 11, 13, and 15-year-old.
Correct.
Yes.
And then you filed a declaration, a proposed parenting plan, financial information, your motion, and then Mr. Ussery, just pulling this up just a second. As far as service, looks like there was service of documents upon Mr. Ussery on, looks like on September 3rd of this month of this year, September 3rd. Looks like all the proposed orders and documents were served upon him. And I'll confirm with Mr. Ussery, did you receive copies of, proposed parenting plans, proposed orders, motions, and the like?
Yes, Your Honor.
Okay. And did you file anything in response?
I did. At first I was not going to, but I changed my mind about that and I filed it. I attempted to file it on Monday, and then the clerk called me back and said that I needed to amend something inside of that filing, so it didn't end up actually getting filed until yesterday morning. At that point in time, and then I had Nicole served yesterday early afternoon.
Okay. All right. Well, I'm glad you provided that explanation, because when I reviewed the file, I saw that, you know, there was service, and so I know what Ms. Elam is asking for. I've got proposed orders. She's submitted her declarations and the like. And then when I reviewed the case yesterday, there's a delay in filing. So when you file something, it doesn't hit my inbox, if you will. Takes a couple days, 2-3 days. And so notwithstanding you filing it yesterday, I haven't seen it. I haven't read it.
I understand.
So I know what you want, Ms. Elam. I don't know what Mr. Ussery wants. So I think at this point, it would be fair for everybody involved for me to know what both parties are saying, and then both of you tell me what your respective positions are after you know what the other party's positions are. So that's kind of a long-winded way for me to say, I think we need to set the matter over and allow me to review the documents that Mr. Ussery has filed, and also allow Ms. Elam, if you want, to file a response to his pleadings or filings. I recognize that there's an existing restraining order. My position would be that I would continue that or extend it until the next hearing, and then we can address the issues raised by the parties. So, Ms. Elam, do you have any questions with that explanation or proposal?
None at the moment.
Okay, Mr. Ussery, do you have any questions about that?
No, I understand the reasoning.
Okay. So let me just ask, as far as your schedules, looking at this, the calendar, today we're the 25th. We could either look at the 5th of October or the 2nd of October or the 9th of October. Do either of you have any conflicts with either of those dates? See, Ms. Elam's looking at her calendar.
No, I do not.
Okay, Mr. Ussery?
I work, so I mean, I just have to take time off of work to be here. So regardless, I can do that.
Okay, all right. So with Mr. Ussery having filed his documents yesterday, it sounds like you received a copy of his documents yesterday.
I do, but I'm a little confused about them. Just because of the content of them. They're the exact same thing that he provided in the protection order. And there are like 5 different people under one signature. So I'm a little confused as to what he's even asking for.
Okay. All right. Well, we'll take a look at that when we come back, and we can, having read that, and I'll be better informed to be able to respond better. Well, let's set it over then to October 2nd. Sounds like both parties would be able to be here. So we'll continue it to Wednesday morning, October 2nd at 9 a.m. for the hearing on the motion for the parenting plan and the other requested relief. I will continue that, extend the restraint order until that hearing is completed. So I'll take just a moment. And Madam Clerk, do you by chance have one of those particular orders that I could? That's great. Thank you. I appreciate that. So I'll just fill that out. It's basically the order that was entered on August 28th will be continued until that October 2nd date. So let me take a moment to do that.
Thank you.
All right,
Thank you.
you.
Your Honor?
Yes.
One thing on that, my name is still riding along as the GAL on this matter, and I never did a report because Mr. Ussery and Ms. Elam did not want to go that route, and it was my understanding that Commissioner Nelson had relieved me of those duties, but yet I got notified on this and stuff, so I don't know if there's anything else that you can do, or...
I am requesting a guardian ad litem if that helps.
So I'm looking at a April 2022 proposed order appointing a guardian ad litem that was filed but not signed.
That was due to the fact that I was looking at relocating for work, and my job offer expired. So I did not end up taking that job, which meant that there was no need for a guardian ad litem because no parenting plan or anything else was going to change.
So Ms. Elam, are you interested in
I am requesting a guardian ad litem in this case. Yeah.
Okay. And then Mr. Ussery, what's your position?
I'm good with the guardian ad litem. The only problem is I'm not, I can't be 100% financially responsible for the guardian ad litem.
Okay.
I make $2,600 a month guaranteed plus commission. So I'm not guaranteed a regular income outside of $2,600 a month. I have a mortgage payment that's $2,500 a month, and the rest of my bills are based off of what I get in excess of that.
Okay.
So
All right, thank you.
Having a financial responsibility of being 100% the responsible party for the guardian ad litem, I don't see as being a fair step.
Okay, and then, thank you. Ms. Elam, what's your gross monthly or net monthly income?
I'm actually not making anything right now
Okay.
because of the mental health issues of the children. I've actually had to take off work because my schedule is filled with counseling appointments and court and needing to pick them up early from school because they're having issues.
Okay, so Ms. Lawrence, have you previously were you appointed guardian ad litem?
I was appointed guardian ad litem, and I got my appointment paperwork about a month after the order was done in court, and I only ever spoke to the parties on the phone. I just as soon, go from the regular GAL registry if they want a guardian ad litem.
Okay. All right. So let's kind of tie that loose end up now if we could. So it sounds like both parties are interested in the guardian ad litem being appointed. And it sounds like both parties, you would qualify for what we call a county pay case. In other words, there'd be no out of pocket for either of you for the payment of the services of the guardian ad litem. So it sounds like you both want me to appoint that person, so I'm inclined to do so. And the way we do that is we have a registry, and it's a rotating registry. So, one person gets appointed, then the next person comes up. So I'm going to give you 3 names of guardians ad litem, and each of you have the opportunity, if you want, to strike any one of those 3. A lot of people don't know them, and so they don't use any strikes, but you're welcome to strike any party. So I'll have the clerk just share those 3 names of the next 3 individuals, and then I'll ask you if you have any strikes.
The next 3 names are Amy Turnbull, Sherry Evil, and Beth Fellows.
I have no strikes.
I have no reason to.
Okay, so neither party has any strikes?
No.
All right, so the first person on the list then would be Amy Turnbull. So I'll appoint Amy Turnbull to serve as the guardian ad litem. The next step after that will be is that she will reach out to you, asking you to contact her and provide her information. And then, so please act promptly upon getting that letter from her, and then that can allow her to start her investigation. And then also just for Ms. Lawrence's benefit, I don't know if it'd be helpful if you need a particular order that says you're discharged, you're no longer involved in the case.
Mattered me, I wouldn't necessarily engage anyways, but yeah, but if my name comes up on court things, yeah, I should probably go ahead and file something, I guess. I thought it was taken care of.
I mean, what I can do, I can just do a quick bench order that says Ms. Karen Lawrence is discharged and no longer involved in the case as guardian ad litem.
That would be lovely, thank you.
Okay, so let me just quickly do that, and then I'll finish up with the parties in just 1 second. Ms. Fellows, I see, or Ms. Lawrence, I see that you're on the line. As far as the final reviews, generally, we're setting those 90 days out. Is that kind of the standard at this point, unless there's a request for something different? Looks like you're muted.
It wouldn't let me unmute. Yeah, the unfortunate problem is that 90 days usually runs any of us GALs into a bit of a problem when it comes to any CPS stuff. But if there's no CPS involvement, then that wouldn't be a problem.
Okay.
There is CPS involvement.
Okay.
Then I would suggest 120 days.
Okay. Thank you. Well, thank you very much for your patience. I appreciate that. So I've signed off on the order appointing the guardian ad litem to investigate related to the parenting plan and all issues that affect the parenting plan and also that affect the children. I'm setting 3 review dates. There'll be a review date on October 30th. That's just a review to make sure that you all have been in contact with the guardian ad litem, that you've exchanged information and that things are getting started. That'll be at 9 o'clock in the morning. We'll have an interim GAL review on December 18th at 9 a.m. for any updates or any concerns. And then the final guardian ad litem report review will be on February 26, 2025 at 9 a.m. And I'm indicating that it'll be county paid, so the county will pay all of that. And I've signed off on that particular order. Any questions from either party?
No.
Okay. If you need a copy of that, you can check with the clerk's office and they can provide that to you. Otherwise, we will see you on the October 2nd. October 2nd. Okay. We'll see everybody then. Thank you.
Thank you.
Double check to make sure we have the parties there. Ms. Turnbull is present. She's the guardian ad litem. I see Jonathan Ussery is on the line, and I'll ask if Elam is here. Okay, Ms. Elam, are you in a position you could please turn on your video, please?
Yeah. Sorry about that.
Okay, great. Okay, we're here today for Ms. Elam's motion for a temporary order appointment of guardian ad litem in a restraining order. I've read her motions and I've read, let me just double check a couple of things so I let you know what I've read. Okay, so I've read Ms. Elam's motions and declarations, and I've read Mr. Esseri's response to those. So ready to hear from the parties. Ms. Elam, you're first. Maybe actually, let me just, if I may, hear from Ms. Turnbull. You were just recently appointed, I think, on the 25th of September, so you may not have a lot of information to share at this point.
I don't yet, and I don't have the party's contact information, so I'm hoping to receive that today as well.
Okay, what information would you like from them?
If they could provide me with a phone number or an email, that would be fantastic.
Okay. Ms. Elam, is that something that do you feel comfortable sharing with Ms. Turnbull, your phone number and email?
Yeah, that's fine.
Or you can put it in the chat if you prefer.
Sure. I don't know how to do chat.
You want to say it out loud, that's fine too.
Do you feel comfortable just verbalizing it and then Ms. Turnbull can take note?
Yeah, that's fine. My phone number is 3.
Thank you.
Okay. Ms. Turnbull, do you have both those sets of information?
I do, thank you.
Okay, great. Thanks. Appreciate that. Okay. Anything else, Ms. Turnbull?
That's all I have right now. Thank you.
Great, thanks. Okay, so we'll hear from Ms. Elam on your motion, why you feel that relief should be granted on those 3 separate items, and we'll hear from Mr. Esseri why you feel that should not be. Go ahead.
Okay, so it has been a very interesting last 2 months with police investigations, CPS investigations. The children have told a lot of people some things. Obviously, I talked about some of them in my declaration. And they are terrified of seeing Mr. Esseri right now, which is why I want to get a guardian ad litem involved. They are having regular panic attacks about even having to see him. I've had to take off work to handle the mental health issues that we're dealing with because of this situation. And I don't think that it's wise right now for the children. I don't think it's in the children's best interest to be around Jonathan Esseri at this time while we figure out what is going on and what is causing this fear in them that they do not want to see Jonathan.
And then just to clarify with you, Ms. Elam, you have a motion for a restraining order and then a motion for a temporary order. And I think the temporary order you're asking for is related to a proposed parenting plan, correct?
Correct.
And did you file, there's a prior parenting plan from 2019 that's in place. Did you file a motion to modify the current parenting plan or a motion for adequate cause?
Not yet. I was really confused about the entire situation. I got a protection order, and that was in place for a month, and that dropped. So I applied for an immediate restraining order, and then I was just confused about the process of it. So I wasn't sure what documents I needed to submit in order to get this going. So this is what I submitted.
Very good. All right. Thank you. All right. Thank you, Ms. Elam. Mr. Esseri?
Sorry about that. Yes, Your Honor. So I'm honestly at a loss because basically what started this entire situation was our daughter being very angry at me because she was being physical in my household and needed to be restrained. Nicole is not a stranger to that with our daughter. In fact, it was 5, maybe 6 years ago where she videotaped our daughter physically trying to accost both her and her now husband. They videotaped it, they restrained her, and then when our daughter came back home to my house, our daughter asked for me to contact the police to file CPS allegations and a police report. When the police showed up, the police went to Nicole's house and Nicole showed them the video of what she did. And the police stated that Nicole did nothing wrong. She was acting in self-defense for what our daughter had done. Well, now the role is reversed and Nicole is taking full advantage of this current situation to give herself the ability without any obstacles to take the children from me, without any evidence towards anything that's being said. At the same time, I have multiple people, 2 of which live in my house, that have typed up statements stating that physical discipline does not happen in my house. The kids get grounding, or they get their electronics taken away, or they don't get allowed to go out and do things that they want to do. Basically the same kind of parenting that any adult does. But right now, it just seems like all she wants to do is strip me of everything. And to be honest with you, I mean, even in her own words in the statement, when Cameron, which, I mean, I understand Nora's really mad at me because I took away her driving school, I took away her cell phone, I took away all these different things, so she's super pissed off at me. Whereas when they asked our son Cameron, do you feel safe in your dad's house? His first and immediate response was yes. Justin, which I believe has been coerced, reluctantly said no. And then all of a sudden it snowballed into me beating them on a regular basis, bruises that have never been there because they've never received a spanking with a belt lined up anywhere with their pants down or without their pants down. My son, Justin, states that out of discipline, because my son Cameron was lighting fires inside of his closet, he stated that I held a lighter to my son Cameron's hand until it blistered and burned. There was a CPS case that I believe was opened by Nicole 4 years ago when that happened, that was shown without cause. It was shut because there was no burns. I didn't burn my son. I didn't hold a lighter to him. I simply was freaking out because my son is sitting in his closet lighting fires. And that's all I did. And now all of this stuff that I don't know where it's coming from is now being used against me to strip my children away from me. And it's all conveniently timed because our oldest son, Brandon, who was a threat to our children before, as soon as he graduated high school, all of a sudden I mysteriously became insane and I hate my children enough to where I'm torturing them based off of the statements that are being made. And it doesn't happen. None of this stuff has happened. It doesn't make any sense to me. It really doesn't. I'm asking the courts to deny the restraining order. I'm asking the courts to deny my needing supervised visits with the kids. And I'm not asking you guys to force the children into my house. I don't see that as being productive at this point in time. I am asking that if they want to come visit me, the ability to visit me. That's all I want. I want the ability to talk to my children again. It's been 2 months since I've seen or heard anything from my kids. I don't know what's going on with them. Cameron went into a mental institution and I had to find out that third party from CPS telling me that he was threatening suicide. I mean, all this has happened in the time that she took control of the kids. This has not happened before. When the kids were in my custody, none of this was an issue. She's sitting here saying that I've denied her parental rights when all I did was set clear boundaries with her about my days off of work in 2020. I had Thursdays and Sundays off. So I told her that she could take the kids after school until 6:30. She would need to feed them. She would need to make sure that they were back home by 6:30 so that they could do their chores, take baths, get ready for school the next day, and that kind of stuff. She never took advantage of that option. She never did. And then when she was having problems with our daughter, Nora, I sat there and she wanted me to put Nora in all these different counseling sessions, WISE program, which denied Nora, and all this other stuff. I put Nora into the counseling that I was able to at that point in time. She was going to Core Health up until the time that she was noted to physically threaten her counselor with bodily harm. That stopped her sessions with Core Health. And then she started going to Columbia Wellness. I have tried working with Nicole on every aspect of this divorce and parenting, but Nicole only wants it her way. She wants everything to be done the way she thinks it's fit. And if I have any opposing thoughts, I am somehow discounting her as a parent, or I'm taking away her parental rights, or all this other stuff. And it doesn't make sense to me.
Thank you, Mr. Essery. Maybe I could hear from both parties just on I understand that there's investigations being pursued by CPS and the police. Can any party give me an update on where those are at, Ms. Elam?
The criminal investigation has been closed due to there not being any proof. any physical evidence that they can find at this time. Because it's been so long since the report that was made, that and they don't live in the house any longer where the event occurred. And the CPS investigation has also been closed because the kids are in a safe place.
Okay, and then as far as your information related to the police closing their investigation, was that a memo sent to you, or was that just a voice communication from one of the officers?
The Detective Jenkins was the one on our case, and she reached out to me and let me know that the case was being closed.
Okay, thank you. Mr. Essery, any input on your end on those statuses?
I know that the CPS case, I'm supposed to be receiving a letter stating how the case is being founded. I don't know what that is. I haven't received a letter. I have no idea what's going on there. I do know that the CPS caseworker did not do her job to completion. She failed to contact material witnesses that I provided to her in reference to what the evidence or the information that she's seeking. So I plan on appealing the ruling that's currently being sent out with the CPS, but that's not involving in this plate. Or
is the CPS ruling, is it an unfounded finding? Is that your understanding?
No. She says it's founded, but again, I haven't received a letter explaining how it was founded.
Oh, okay. And then Ms. Elam, just for clarification, is that your understanding that the CPS investigation is closed, it's done, and they had a founded finding as opposed to an unfounded finding?
I did not get that information on my end of it because it was a case open against Jonathan. So they can only give me very limited information because it was not a case open against me. So at least that's what the CPS worker told me. I actually had two CPS workers working with me, one that was mine and one that was his. Mine was closed, unfounded. And I haven't received any other information other than them reaching out and asking if there was anything else that I needed from them.
Okay, so you haven't received, neither Mr. Esser nor Ms. Elam have received any written communication from CPS that said, hey, we've closed our investigation and this is what we found or didn't find. Neither received anything like that.
That's correct.
Okay, all right. Okay, thanks. Okay, so there's a couple items that we're looking at. One is that the guardian ad litem has been appointed, and she's got contact information. So I'll anticipate that both of you will be communicating with her so she can prepare her report. That's important because procedurally the case is, and this isn't uncommon in the self-represented world. There's absent a motion to modify the parenting plan or a motion to find adequate cause. And that's probably just due to lack of familiarity with the system. So I'm denying the motion to modify the parenting plan. However, it can be refiled, but it has to be filed seeking a motion for adequate cause to modify the parenting plan. So Ms. Elam, I'm denying it now with leave that you can file the proper paperwork to modify the parenting plan with a finding of adequate cause. That's kind of the first hurdle. The idea is that once a parenting plan is put in place, there's a desire for stability and consistency, and that only a parenting plan can be changed only once there has been a finding of adequate cause, that there's sufficient reason that there's been a change either with the children or one or both of the parents that we should change and modify the parenting plan. So you'll need to bring that motion fresh if that's what you want to do regarding adequate cause and the modification, but I'm denying that portion at this point. So that focuses the court's attention on the motion for a restraining order. Here, the motion for a restraining order is based on concerns brought forward from an alleged assault occurring at the end of June on the oldest daughter. And then also it came to light that there's potential allegations involving sexual misconduct involving the eldest daughter. And that there was a CPS investigation related to that. And there was a CJAC interviews, which is a forensic interview of children that occurred that were observed by Officer Jenkins, who was the lead investigator. And that there's information that the children, at least two, that have experienced some sort of suicidal ideation, including the eldest daughter, who actually went to some type of an inpatient treatment center for a period of time. There's some older allegations related to lighter and the fire. I'm not really necessarily considering putting a lot of weight on those concerns or those issues that have been raised, and that there's potential motivation for the eldest daughter to be upset related to privileges being taken away. What was particularly concerning to me was the information from Detective Jenkins when she observed the children at the CJAC or forensic interviews, where she's done many of those and she sees common reactions of children in that setting, and it struck her as highly unusual that the children were exceptionally frightened or terrified of their father, and I think that speaks to speaks to me of a significant concern that is there, that's present. So what I'd like to do is this. I want to set a review for November 4th at 1 p.m. I'm hoping Guardian Ad Litem Turnbull and can quickly provide just some focus to the court or some kind of emergency information, if you will, related to the well-being of the children in relationship to the father. Between now and then, so that'll be on November 4th at 1 p.m., I'm going to continue the restraining order against Mr. Ussery with the proviso of allowing supervised visits, and I'm not going to require a professional. It'll be a third-party lay non-professional guardian, and I'm going to ask both parties if you have an individual or individuals who could serve in that capacity. Ms. Elam, do you have any suggestions?
I cannot think of anybody off the top of my head without asking prior consent.
Okay. Mr. Ussery, do you have any individuals?
So I've got several that I can request from my church, and then also my mother-in-law, who knows the children and has been around them and spent time with them, so they're familiar with her. And I believe she would be able to be present to supervise visits as well.
Okay. Ms. Elam?
I would prefer that it be somebody that does not have familial ties. So I would prefer that the mother-in-law is not it. There is a woman in the church that my daughter is very fond of named Rhonda. If Rhonda could do it, then I would be okay with that.
Mr. Ussery?
I would have to reach out to Rhonda and request permission or request her assistance.
Sure.
But I don't have a problem with Rhonda being present for visitation.
The children on Saturdays and Sundays, do they have activities in which they're involved on a regular basis, kind of in the short term here, like soccer or music or?
Not at the moment, no.
Okay. So what I'm going to allow is I'm going to continue the restraint order, but allow for supervised visitation by a non-professional, somebody within the church congregation of Mr. Ussery that's agreed between Ms. Elam and Mr. Ussery. If Rhonda can do it, great. Then if not, then there would need to be another individual that the parties agree upon. Just has to be an agreed supervisor from the church congregation. And I'm going to allow 3 hours on both Saturday and Sunday until we get to November 4th at 1 p.m. where we will review. So the exchanges will occur. I think that needs to be just at a public place. If you parties have a suggestion, if not, it'd be the Hall of Justice.
Your Honor, I live 30 minutes away from town.
Okay.
So visitation both Saturday and Sunday is quite a trek for me in and out of town every single day.
Where's your home located?
I live in Silver Lake, Washington.
Okay. And Mr. Ussery, where are you located?
I live in Longview.
Longview. Okay. Is the say the Castle Rock McDonald's, is that a roughly equal? So it's about 15 minutes up from Longview to that location, and maybe Silver Lake to that location is about 15.
That is.
Yeah.
Let's set the location at the exchange location at the Castle Rock McDonald's. So that'll be starting this Saturday and Sunday, 3 hours. If the parties can't agree, it would be from noon to 3 p.m. on both of those days.
Okay. I have.
So there's some questions. So we'll hear from Ms. Elam, then Mr. Ussery.
Okay. What if the children refused for visitation? What do I do?
You as the parent need to make sure that they're there present for the visitation.
Okay.
Mr. Ussery?
I just would like to amend the time frame for Sunday to like 1:30 because I attend church from 9 a.m. to noon on Sundays.
Okay.
And so that time would allow me to obviously be done and then coordinate with Rhonda to be able to, and I question, would Rhonda be the one that would need to go up to the Castle Rock and pick up the kids?
Yeah, both, that's where the exchange location would occur for both the drop off and the pickup would be at the McDonald's in
Well,
Castle.
no, I'm asking would Rhonda be the one that needs to pick them up?
Um, that might make it easier, Ms. Elam.
Yeah, it would make me more comfortable, most definitely.
Yeah, I'm fine with that. So the supervisor would be the one picking the children up and dropping off.
Okay, then could I get an additional half hour because of the drive time?
I'm not going to negotiate. So we'll keep it to the time Saturday 12 to 3 and Sunday 2 to 5. And then the supervisor will do the drop off and pick up on those dates at the Castle Rock McDonald's. And then we'll just get the review from the Guardian Ad Litem on November 4th. So please be responsive to her communications.
Okay.
Thank you.
I'll draft a brief bench order to that effect. And so if the parties need a copy of that, you could check with the clerk and get a copy.
Okay, thank you.
Okay, thank you. That'll conclude
you.
the hearing for now. We have Mr. Roberts representing Lawrence Beal. I see Mr. Roberts is here. Ms. Gilmore is also here. You're representing Jessica Krebs. I see Lawrence Beal is present, and I'll ask if Ms. Gilmore is your client, Ms. Krebs, on the line.
He is, Your Honor.
Okay, very good. Welcome to everybody. Just a moment. And just as a friendly reminder to the attorneys, my intention, and it doesn't always manifest itself, is to call your cases much earlier in the docket. And so if I get going on a docket, feel free to interrupt and say, Your Honor, we're here on such and such a matter. That would be a nice prompt, and I apologize. So with this matter, we are here on Mr. Beal's motion for temporary orders related to parenting plan, guardian ad litem, the remaining lease, and then also looks like Ms. Krebs had made a request related to spousal support. So I think the main motion is on the parenting plan, and also there was a request for child support and spousal support, but at least my opinion, I don't really have a clear picture on either party's finances or monthly incomes or expenditures. I realized there was a financial declaration filed by Ms. Krebs related to that, but so I'm just throwing that out there to let you know that I'm likely not going to rule on that and reserve on spousal support and child support, but we'll be taking a look at a parenting plan today.
Yes, Your Honor. I expected that as a husband failed to provide or request that within his motion, my staff have subsequently filed a motion to address spousal support and child support. So I think that will be addressed in the next couple of weeks. So I didn't expect to move forward. We did ask for attorney's fees. If the court wants to reserve that for that financial motion, that's fine. But I did expect to just move forward with the parenting plan today.
Thank you. Mr. Roberts.
That's fine. Ms. Gilmore and I spoke, and I think what happens today will also impact the spousal support and the whole support termination. So my intent and my hope is to go forward on just the parenting plan, and we can take next steps afterwards.
Okay. All right, great. All right, thank you. I appreciate both inputs. So Mr. Roberts, this is your client's motion. So I'll hear from you, please.
Thank you. So, Your Honor, this is a short-term marriage with a young child who has had both parents at home mostly all day, every day since birth until their separation. The parties shared care since birth. My client quit his job to live on his investments and savings to be a stay-at-home parent during these formative years, and that still remains his intent today, even with the separation and his capacity as well. Mother frames this case by accusing my client of manufacturing a new status quo by adding overnights. The reality of the case is there is an initial status quo that everyone was following without issue, 7.5 hours a day, every other day. Mother claims she agreed to this under duress. There's no email provided showing this. Her initial email proposal per my client was for 6 hours a day, 3 days a week, negotiated up an hour and a half, and a half a day added. There was a joint understanding at that time overnights would come, but there was a disagreement over how they would begin. After the overnight situation, mother retaliated by withholding the child for 4 to 5 days, only allowing my client contact for 2 to 3 hours, only if she was there to supervise, a marked difference from what she had agreed to and been content with for the period before them. This 2 to 3 hour period of time increased to a second status quo of 7 hours a day, 3 days a week, not by my client's agreement. He was asking for the initial status quo to be reinstated, but he was avoiding creating a scene, and mother was allowing it to be ratcheted up and to keep the peace while he worked with me to get this filed. That was where they got to. So we're at 7 hours a day, 3 days a week for a second status quo. During this time, he asked about an overnight on his birthday. She rejected it. He didn't fight about it. Then he said, how can we work up to overnights? Opening the conversation. In direct response to that question, without responding to it for 2 days, at 10:34, the night before he was supposed to have his next 7-hour visit, she said, you're only getting 2 hours tomorrow. It's going to be in a public place, and I'm monitoring your car the entire time. After a week of these irregular visits where she's monitoring his car 2 to 3 hours, she then allowed what is currently still going on, which is 3.5 hours where she drops the child off, and he has a child for 3.5 hours, 3 times a week. The fact of the matter is, mother manufactured her own restricted status quo as the court approached, what appears to me to be for leverage in court, so she could anchor things at this rate. There's nothing in the record suggesting that the first or even second status quo periods of time were detrimental to the child. Yet she has repeatedly manipulated the schedule to deprive my client of time that she had previously agreed was appropriate. It's important to recall and to keep in mind that my client has 9 years of prior child care experience, often caring for 5+ toddlers at a time. To say he's not equipped to handle his own child more than what she is currently allowing is simply indefensible, not supported by the record. These people are getting divorced. They obviously have issues between the two of them, and that's why they're not together. But it seems to be, whether directly or indirectly, she's trying to hang her hat on the character assassination attempt for him and shoehorn that into him having less parenting time, when she didn't articulate a single thing in the past 2 months other than the overnight situation that gave her any trouble. She mentioned a crusty diaper when she's talking to the police, and the police are telling her, we can't get involved, you need to go to court and get an attorney. But she doesn't take a photo. She doesn't give my client a text message or email saying, I can't believe you did this. This is why you can't have overnights. It doesn't exist because it never happened. I'm not going to go through the litany of issues that my client did articulate, because I know the courts have read that. So I just want to highlight a couple more things. There does appear to be a pattern of interference and control from mother, in addition to what I've already explained with the pulling back of time. She created conflicting plans in May when she knew about my client's out-of-town visit with family. She invited her mother into town well after she knew. This is a pattern of her using the child when she doesn't get her way in the interpersonal relationship with my client. They should they are getting divorced, but there's nothing preventing the initial status quo from taking effect immediately. It's also important to mention, she never mentioned to the police any concerns with the child's well-being in my client's care, simply to solve a dispute that could only be solved by coming in front of you. I also want to briefly point to some unreliable statements she made that we combated with text message collaboration. She tries to character assassinate my client by saying he was abusive. He demanded I quit my job. Well, there's a text message that we provided where she expresses extreme joy on the morning where she's going to put in her notice and afterwards. She blames my client for early pregnancy because of his behavior that she never mentioned. There's no collaboration elsewhere. However, my client says she was using marijuana.
Well, I have to object to that. That was contained in the reply. My client didn't have the opportunity to respond to that. I would also note that in their parenting plan, they failed to note any 191 factors. I'd suggest that if my client was consuming marijuana while in utero, that would be an issue given the age of this child.
The reason why I'm mentioning it, Your Honor, is because she, in her response declaration, blamed my client's behavior for her early pregnancy. The fact that that opened the door for him to say, well, she was smoking marijuana and I had to send her this article in January because she wasn't stopping. The court can take that as it wants. I don't think it's dispositive here, but it's another piece to consider in the grand scheme.
The objection is noted, overruled.
Additionally, the mother provides this submission, which is late. I don't know if the court's going to consider it, but briefly touching on it, because my client did file a response submission as well. This submission that it looks like she's trying to convince the court that through this submission that my client is unreasonable and micromanaging. However, the first or the second indicates they're both kind of annoyed with each other. She leaves the house. He's upset about it. He says that she's interrogating him. This is why they're getting divorced. The point that I want to draw the attention to, and what my client's submission response, articulated, was she ends her exchange with her saying her appointments are in the calendar. Her text is cut off right in the middle. Well, my client's response text was, your appointment says you were done at 1 o'clock. They're having this conversation after 4 o'clock. My client left her alone for 3 hours. He didn't know where she was. He's about to make dinner, but she is, just like she's been doing in the rest of the declaration and what's been consistent with what looks like what's been happening the past couple months, is that she is taking a snapshot of something, not providing the full context, and pointing the finger in a smear campaign to make him look like he's someone he's not. The bottom line is my client has childcare experience. These folks were having a status quo of 7.5 hours every other day until the overnight situation happened where mom retaliated. And then the second retaliation was even more bizarre, as if this was crafted to withdraw time prior to coming to court. So my client's position is that his parenting plan should be adopted, or one of those two status quos. Obviously, he's preferring the first status quo because that was what they did agree to. It is more time, but mother simply has no reason to pull back the first or the second status quo. And I don't believe her parenting plan is supported by anything in the record whatsoever. If the court is willing to accept my client's parenting plan or some variation of it without a GAL, that's fine. But a GAL may be the right approach to address the issues and the lack thereof, as far as I'm concerned, to put these issues behind so we can graduate to my client's parenting plan and ultimately the school schedule. Thank you.
Thank you. Just a quick question, if I may, Mr. Roberts. There were some medical records, looks like the baby's well child checks and the like, and it shows that the mother was the one that was there taking the child at least on maybe 3, maybe 4 appointments. Is your client involved with that?
My client addressed that in his reply declaration. I'm not, that's not to wag my finger at the court for missing that, but he went to, I believe it was 4 is what he put in his reply declaration. There were a few that he missed due to appointment conflicts he had at the pre-scheduled appointment conflicts, and there were, I believe, 2 that she never informed him of. So of course he didn't show it.
Okay.
And that was articulated in his reply.
Yeah, I did read that. Thank you for reminding me.
No problem.
Your client is asking for a 2-day, 2-day, 3-day, and then a 2-day, 2-day, 3-day, with each parent having the 3-day weekend.
The parenting plan, Cowlitz is a little unorthodox in that the parenting plan needs to be filed. We filed the case initially, so we didn't file it concurrently with the declaration. He understands that that's not going to happen today. That is his goal. That is his goal prior to school age children, under school age children's schedule. What he's asking for is to work up to that, because that is a reasonable schedule with minimal transitions for a 50-50 plan. The full week at this age, or even age 2 or 3, is something he's certainly willing to not have that full week on, week off plan. But initially and immediately reinstate the 7.5 hours every other day.
Thank you. Right, Ms. Gilmore.
Yes, Your Honor. For the record, Megan Gilmore on behalf of the respondent and non-moving party, namely Jessica Krebs. My client was a stay-at-home wife and later mother prior to and after the birth of the party's daughter, who was born in March of 2023. As detailed in my client's declaration, this relationship was plagued by husband's emotional abuse, coercive control, and financial threats. I think looking at the tone of husband's reply speaks for itself, as he labels my client a paid household assistant despite the parties being married. Despite husband's claims, my client has been addressing her mental health due to this abuse since prior to the birth of the child. Within the evaluation filed under seal dated November of 2022, my client discloses the emotional abuse of husband and her safety concerns to her provider. She details to the court in her declarations that husband threatened to drive off the road while she was pregnant, and he indicated that he only married her because he was suicidal. After the birth of the child, my client was 100% responsible for the child's care. Despite caring for a newborn and then later a toddler, husband would become irate if my client wasn't meeting his expectations as it relates to household chores. Again, really looking to that reply declaration, he doesn't deny that, and in fact claims that my client's too sensitive, but doesn't deny that he's on top of my client despite her being the primary parent of this child. When my client would ask him to briefly care for the child while she did the chores he demanded, he would want to know the exact minutes that he needed to provide care, as he claims this wasn't his job. This was confirmed within the text message evidence where he was irate that she was gone for several hours. We can dispute the timeline, but it was very clear that he was uncomfortable about caring for the child for a short period of time. Husband's abuse only escalated as he would scream horrible names while in front of the child to my client. He later refused to allow my client and the child to sleep in the master bedroom because he didn't want to lose sleep. My client continued to be solely responsible for this child as they lived and often hid in the nursery from husband. My client explains the situation where husband had no patience for this young infant and turned his anger on the child as well. Husband would repeatedly threaten to cut off financial support, which frankly he doesn't deny, and would demand my client leave the house even with the child, so move out without any sort of financial support. My client gives you a detailed timeline of ongoing cycle of domestic violence that took place until she finally moved out for the first time in March of 2024. I'm sure the court has reviewed those pleadings, so I won't go into every incident.
Ms. Gilmore, can I ask you a question?
Yeah, absolutely.
So the term domestic violence can be broadly interpreted, narrowly interpreted. There's no claim, I don't think, from your client of physical violence. It's more of emotional control or concerns related to power dynamics.
Yeah, I've had experience in law school and domestic violence, and I term it in the broad sense. Sometimes that mental and emotional abuse can be as severe as hitting someone in the face.
Thank you.
Moving forward, rather than caring for the child, husband used his visitation as time to reconcile with my client, make threats when she refused, and demand she continue to do household chores even when she wasn't living at the residence. When it became clear that my client didn't want to get back together in June of 2024, husband threatened to seek a restraining order as well as emergency custody. Following this conversation under duress, my client agreed to the 7.5 to 8 hours of visitation every other day that the parties initially exercised following their separation. Husband claims to have experience with children, but fails to mention that this alleged experience happened over 20 years ago. Moreover, looking at what the status quo is today, he has unreasonable expectations for his own daughter that's been bore out since separation. My client explains in the declaration that he expects a 1-year-old child to express when she is hungry and doesn't feed her absent that. The child initial visitation at the 7 hours following separation, the child was left distraught and severely hungry, despite my client repeatedly trying to address this with him, reminding him that he needs to be offering food on multiple occasions throughout the day to ensure the child is adequately nourished. Husband continued to use visitation as exchanges as an attempt to reconcile with little interest in actually caring for the child or co-parenting. My client explains in her declaration at the exchange on July 30th, husband became irate when my client again confirmed he didn't want to reconcile. At that point, he told my client that he would keep the child unless she was willing to get back together. In good faith, at the following visit, and frankly out of fear, my client provided father the agreed daytime visitation on August 1st. Husband ultimately, despite the communications that it would only be daytime visitation, made good on his threat and refused to return the child. And not only refused to return the child, but didn't stay in the community residence in efforts to conceal his location. My client only called law enforcement based on her concerns for the child's safety due to his violence and mental health. She specifically referenced to law enforcement that this was in retaliation, and she was concerned about the welfare. This isn't an individual that's trying to abuse the law enforcement process, and frankly, as the court's aware, law enforcement often won't engage, but my client was concerned for the child's safety. When the husband finally agreed to return the child the next day, my client explains that she wasn't changed, her diaper wasn't changed, and she was visibly despondent. Again, in good faith, 2 days later, my client was again willing to facilitate visitation based on the agreement of the parties that he would have daytime visitation based on their prior agreement. So this was on August 4th. When my client again attempted to pick up the child, he refused to do an exchange. The next day, the child was exhausted, hungry, and withdrawn, as explained in my client's declaration. So this isn't an individual that's unilaterally taking time from a father without a basis. The parties had an agreement. The agreement, frankly, wasn't even going well with the time that was provided, but my client was willing to comply with that. Even after he went outside of the agreement and kept the child overnight, the next 2 days later, my client was still willing to provide daytime visitation. It was only after the third time where he continued to threaten for overnight visitation that my client had to establish boundaries and determine that she has to act in the best interest of the child. It's not in the best interest of the child at this point to have overnight visitation, which frankly is acknowledged by husband. My concern in this case is father is using child as a pawn to further abuse my client emotionally and has really no interest. I mean, I'm sure he has an interest in having a relationship with his child, but his primary focus is reconciliation and retaliation to my client by keeping the child overnight. So my client does believe that the current daytime visitation schedule for shorter periods of time more frequently throughout the week is more appropriate in the best interest of the child. Given the disparity of incomes, we are asking for the court to award attorney's fees in this case.
Thank you, Ms. Gilmore. Mr. Roberts?
So I'll briefly respond. Much of what Ms. Gilmore mentioned was disputed in my client's declaration. Additionally, I want to point out the paid household assistant title was prior to marriage. That's when they were discussing it in that way. And it was her function to help with the farm. I mean, I think it's overstating it to make this out to be some. I'll leave it alone. But that was a prior to marriage conversation and label. With respect to not denying certain things in my client's declaration, he had 4 pages and he had a lot to get through. He starts off his declaration by stating anything I don't have time to explicitly address here, I fully deny and dispute. So if we had to go through everything, there would have been insufficient room to do so without going well over the page limit, as I know the court understands. With respect to the dynamic, we've already addressed that. I won't belabor the point. She claims he's abusive. He counters by saying she was demanding I had to walk on eggshells. She said I had to be a doormat to have this relationship in any way, and anything that I said was unacceptable unless it was exactly how she wanted it. This is why they're getting divorced. There's no corroboration. I know that she went to therapy. There's some notes about that, but there's nothing about any texts or emails where she's talking to him or anyone else about these specifics that now she's bringing up for the first time. 5 months after she leaves, several months after she calls the police, doesn't go to court. She had her financial situation, as far as I can tell, didn't change from July until now, and she chose to not file a motion or file for divorce because she was content staying out of court and working on it outside of the legal system. My client was the one who was forced to bring this to you. She knew of the rental. He got access to it that day, as he explains. I think we've covered those issues, but I think she's overstating what actually happened there. Maybe I misheard Ms. Gilmore about saying it was the third time when she finally had to ratchet up pulling back time. There was no third time. There were the 2 initial overnights, and that was when she pulled back to a couple hours, but then went up to the second status quo, as I referred to it, which was 7 hours a day, 3 days a week. Nothing happened, even according to her declaration, after that 7 hours a day, 3 days a week, other than my client asking how we can get to overnights. There were no threats. There was nothing in the record whatsoever, and my client clearly explains, I asked about how do we get to other overnights? And then the next thing I know, at 10:35 p.m., she says, tomorrow you're getting 2 hours and I'm not leaving. That's where we are. So even according to everything she's provided to the court, even she upped it to the 7 hours a day, 3 days a week. And it seems that the only change from that point in time until now is she got upset about him asking, and court's approaching. So why would she loosen the existing parenting plan? It's working to her advantage. So the status quo initially is obviously what my client's looking for. I've discussed all those issues. But the second status quo, mother has said nothing since that August 2nd status quo and why that shouldn't be in place. So I'd submit to the court and ask for my client's initial request, and if not, then the second status quo to be in place immediately while we wait for JL findings.
All right, thank you. Ms. Gilmore.
Just briefly, Your Honor, I just wanted to talk about the second status quo. After receipt of the motion, we needed to have the matter set over because it wasn't timely. That second status quo was based on the agreement to get the matter set over. My client still has the belief that, again, shorter time for more consistent is more appropriate for the child. In good faith, we agreed to do the 7 hours because there was 2 attorneys involved, but I don't think that my client's necessarily stipulating that that's agreed.
I want to clarify that. The second status quo I'm referring to is what happened before she was served with any documents. It was on 8/17. My client asked for an overnight. I'm looking at his reply declaration right here. She said no. He conceded, asked how we can work up to overnights. 8/19, 10:34 p.m., the day before his next visit. We filed on 8/20. So this is before all of that. That's when she said, you're getting 2 hours. It was 7 hours the week before filing. And then it was ratcheted down to 2 hours a day the day before we filed. The conversations I had with Ms. Gilmore trying to negotiate things until today were my client wanted to go back to 7 or 7.5 hours. Mom said no. So instead of my client creating an absolute chaotic scene, so Your Honor would have to hear about this, he had no choice but to acquiesce because mom was using the threat of calling the police and blowing things up. But the second status quo from mid-August, there's no reason to deviate from that. Mom just did it because she did not like that he asked about overnights again, period.
Right, thank you. Question for both parties regarding appointment of guardian ad litem. Do we want to address that today? Have the next 3 individuals on the list and take care of that now?
I think that's probably, I don't know if Ms. Gilmore has an opinion on that, but I think that's probably inevitable. If the court's willing to grant my client's request, then no. But if the court has questions about how to ramp things up to whatever you are going to allow, or what it should be ramped up to, then a guardian ad litem has to happen. If you are willing to go to the first status quo, the every other day 7.5 hours, and have some ramping up schedule to a 2-2-3 without a guardian ad litem, sure, we can save the effort. But other than, if you're not willing to do that, then I think we should get it moving as soon as possible.
Ms. Gilmore.
My client will stipulate to a guardian ad litem. I think given the age of the child and the accusations in this case, I think it is inevitable. I'm a little apprehensive on, I mean, I guess we're not going to enter an order no matter what today. Maybe we can rule on presentation on the percentages. It's definitely going to be at least private pay to a vast majority, given the finances of the parties, but maybe we can set the presentation on for the same day as my motion for child support, and we can address it all at the same time.
I'm okay with that. Ms. Gilmore and I did talk about, depending on what happens here, if we could maybe, no promises, work on support order outside of court. But either way, I think how you initiate the payment isn't going to be a huge issue. If we reserve it, or if my client pays in full but subject to reevaluating it just to get it started, it seems to be a difference of maybe $1,000 down the overall, so we can figure that out however you want to do it.
Great. All right. Very good. Thank you both for your input. All right. As far as the parenting plan, my impression of the case is that the parties are struggling to make things work. So they both have very different ideas of how things should go forward with the daughter. And I don't doubt that there's been power and control issues and struggles. One party has really strong views of how things should happen. The other party has equally strong views. And there's a lot of dynamics that happen in relationships that I'm getting a glimmer of in the pleadings with the parties. Is it unusual for maybe the parent who doesn't spend as much time with the child to be concerned about a parent when they're going to return? Mr. Roberts indicates, as the schedule was planned that Ms. Krebs would be back around 1 o'clock. He indicates that his client started communicating about 3:30, just checking time frames. And on the other hand, Ms. Gilmore paints a different picture, that he was very much of controlling things and ruling the roost, if you will. So those are things to be aware of as it potentially affects the well-being and the best interest of the child. What is, I think, clear to me is that the parties at some point during their parenting of this child and their separation had agreed upon a 3-day-a-week parenting plan for a relatively substantial period of time of 7.5 hours. And then there's been some struggles with that as the case has moved forward. So I think, there's, some argument to be made that, how do you get experience in parenting a child? You parent a child. If you've never parented a child, then there's opportunities to do that through parenting a child. There tends to be that when mothers give birth to a child, that they tend to spend more time with the child, because if they're breastfeeding or what have you, then there's a greater need for that connection and time spent with mothers. On the other hand, the indication here is that the parties were not actively employed, that that father was in the house. I know this is contested, that mother would indicate that he didn't do as much, and she was forced to do an inordinate amount of the work and the like, and that there was power and control pushed upon her, foisted upon her, and that's supported by some mental health records early in the relationship, that there is this emotional control and abuse occurring. So I think, given those factors and the fact that Mr. Lawrence has some exposure to children, it doesn't sound like through different past employments, but it doesn't sound necessarily like they're really small children, probably older children. Nonetheless, there's some exposure there. So I'm comfortable with the 7.5-hour visitation for the father three times per week. I think that's fine. As far as the guardian ad litem, I think that's the suggestions well taken from the parties to set that to either the child support hearing, or to set it for a separate or at the presentation docket. Either of those would be fine with me. As far as the decision making, I'm not making any findings under 191. So at this point, under this temporary basis, there'd be joint decision making related to school or educational pursuits, and also non-emergent healthcare. So other than that, I don't know if the parties want a greater specificity on other requests, or if that's something the parties can work through. So I just hear from the parties.
I don't want to speak over you, Ms. Gilmore, but I think there isn't too much in conflict other than the schedule. Ms. Gilmore, do you agree?
I think that we can work out holiday time. I think that's what the court's looking at. So we can work out holiday time. Anything that's outstanding, we can address at presentation or at the next motion hearing.
I think that's fair. And Your Honor, I'm not trying to re-argue. I just wasn't sure about your thought process. I just want to be clear, the first status quo to 7.5 hours was every other day. If you were intending to go back to that time frame, it was every other day. If your intent was to say, no, it's going to be 3 days a week instead of every other day, I'm not re-arguing it. But can you clarify, please?
So I guess, I mean, your point, I think, is that if it's alternating days as opposed to 3 times a week, that provides additional time for father on a calendar.
And that's what they were doing before the overnight situation. That was the first status quo.
Yeah, so if you look at a calendar.
So it's not going to work for school age kids, but with the flexibility, both parents and the kid don't know Monday from Friday. So
True. So, if you look at a calendar, if the alternating days would be implemented, that would be potentially, say, 5 days in 1 week, and then the next week would be 3 days. If you kind of do an alternating, if father had a visit on Sunday, they'd have one on Tuesday, then Thursday and Saturday. Then mom would have her visit on time with the child on, or the next week, the father would have it on Monday, Wednesday, and Friday. So that's what you're getting at, Mr. Roberts, is there'd be an increase.
Yeah, well, the principal difference was, is the court going to grant the status quo 1 to the status quo 2? But the practical difference would be over a 2-week period, you're talking about 7 days versus 6 days.
Mm-hmm.
And if I can speak to that, Your Honor.
I think I'm going to do that every for 3 days per week. 3 days per week.
Okay.
And can we get clarity? I don't know. Well, I think they're doing 3 days a week right now. Maybe we can work this out, but I just want clarity that the 7.5 hours would start immediately. Is that the court's understanding?
I don't see any reason to delay that.
Okay.
Understood. I assume all oral rulings are immediate.
Yeah, and I appreciate that clarification. And then as far as attorney fees, there's a request for that. I'm going to reserve on that until I have a little clearer picture on things. But that can certainly be readdressed.
Do we want to set a presentation date at this point? I know Ms. Gilmore is talking about filing and setting a motion, but
I think that's
go ahead.
I think that's being couriered over. So what my staff can do is just note it on for the motion as well as presentation. So we can hold off on setting presentation today just to make sure it's simultaneous.
I'm fine with that.
Okay. Yeah, as long as you're setting it for the presentation and any additional items on the same date, I'm fine with that also.
Great. Right. I appreciate it. Thank you.
Any additional items from you, Mr. Roberts?
If so, I'll kick myself when we end the call and regret not saying anything, but I think we're good.
All right. Ms. Gilmore, anything from you?
I don't believe so. Thank you.
Okay. All right. Thank you very much. I appreciate that.
Thank you both. Have a nice day.
All right. So Mr. Williams is president. I'll ask if Nancy Wilson is on the line. All right, Nancy Wilson, if you can hear me, please make sure you're unmuted and state your name, because at this point I haven't been able to hear you. Nancy Wilson. All right, there's no response there. And then we have, looks like Ms. Russell is present here representing the State Division of Child Support.
Yes, I'd just like to inform the court that the state has out for service a response on this petition and will be entering into appearance, has not yet. So if support issues are raised, I would ask that they be reserved.
Very good. It looks like Mr. Williams served documents on Division of Child Support on September 23rd, thereabouts.
Yes.
So yeah, we can certainly reserve that and allow the state to have opportunity to respond. So we have, Mr. Williams, this is your motion related to a parenting plan, terminating a restraint order and a guardian ad litem appointment. It looks like you served properly, Ms. Wilson, on September 4th, 2024 with all the appropriate documents. In looking at the file, I don't see that she's responded. Have you received any communication or any documents from her?
No, Your Honor, I have not.
Okay. All right. So here, one moment. Your proposed parenting plan related to Paisley is that there would be joint decision-making, that you would be the custodial parent, and that the, bear with me one moment. That Ms. Wilson's parenting time would be alternating weekends, Friday end of school to Friday at the start of school.
So something like that.
So is that a week on, week off?
Yes, that's
Okay.
where at the moment. Yeah, I'm so first real quick. I apologize to Your Honor. I had admitted into Hope Court. I don't know if you remember me.
I thought of that, and
and I apologize. I ended up hanging myself to stress of everything. So I apologize to you, Jade, Heidi. Everybody's not here. If you can convey. But I got that took care of. That's been a long 2 years.
Okay.
Recently I had been with Nancy. We got our daughter back out of CPS custody. Everything was going good. I was there for about a year. I decided to go to jail, take care of my DOC stuff. I got out of jail and I found not only a registered child sex offender at the house, but another sex offender at the house. In lieu of that, Nancy started using the court to kind of buttress her keeping me from my daughter, where I was under the impression, hey, if we're not romantically involved, if you want to see your daughter, it's no problem, come see her. So I had gotten a job, where it would allow me. I was driving a taxi. I was going to take my daughter one day, pick her up, just drive around with me for a couple hours, just, daddy-daughter thing. Like I said, it's been a long road to get back to where I am now. And instead of being able to pick up my daughter, I was serving a no contact order. Miss Carmi told me that I had to, because I had put into the parenting plan. She didn't have it at the time to rule with the no contact order, which I'll say is being used just to hinder my ability to see my daughter, to manipulate the police into arresting me and taking my employment, stuff like that. I really have no problem with it. But my problem is that I am one of them people that the world's cruel as hell. And when I trade off my daughter, I would like her mom to be able to get her from me, because you never know if driving away you get hit by a truck and that's the last time you see your kid. You know what I mean? And I feel it's important that, I have no reason to go over there, bug them, but this has all been put in because I had happened to come home and catch her in this situation where this is where it all started, the CPS stuff. And, instead of going law-abiding citizen craziness, and I figured that I'll do what I have to, go through the courts. And, like I said, it's been a long road. Past couple of years, I got my mental health out of the way, drug addiction out of the way. I got evals done. I shouldn't have to be doing this. You know what I mean? I was under the impression that I would be able to come home and see my kid after I did everything, got everything taken care of. And instead I came home into a situation where my daughter isn't in a good situation again. And, in order to keep me from bringing this forward and making light, I had submitted documents from witnesses, statements from Nancy herself saying that she was going to use the courts to manipulate my being able to see my daughter and stuff like that. And honestly, I just want to be fair. I love my kid. I haven't seen her since before Father's Day. That's all I've been trying to do is see my daughter. And I've been, oh, you're not going to see your daughter. I'll put no contact orders on. I'll do all I can. You know what I mean? And before I went to prison, which is another reason, a guy asked me to shoot him. I didn't just go randomly shoot somebody. He asked me to do it. Bad choice making, on my part. But it wasn't malicious. It wasn't nefarious. It was just, okay, I'll help you out. I mean, I've never had anyone ask me to shoot him, but yeah, I'm not violent. I'm not after her. I don't cause trouble at home. Like I said, I had statements and everything laid out for Miss Carney, and she decided to just have me go through the family courts. So that's addressing the no contact order. You know what I mean?
Can I ask you a question about that no contact order?
Yes, sir.
I wasn't given a copy of it, and your name is I won't call it unique.
Joel.
It's not unique. So when I do a search by name, it's difficult to find it. What's do you mind sharing with me your
J-O-hyphen-E-L.
It's
Joel.
Do you mind sharing with me your date of birth?
08/16/1978.
All right. I'm just going to pull up that.
Yeah, I've been dealing with this for like 46 years now.
So this is a matter that Commissioner Carmi heard. Let me just pull it up here. And okay, there it is. Okay, so it looks like this was entered end of August 26th. Okay, so let me just pull that up. Okay, thanks for your patience. I appreciate that. I looked over that. So let me ask, Mr. Williams, as far as you mentioned mental health treatment, where are you with that?
So when I hung myself, I went to the state hospital up north in Marysville. That was 2 years ago. I was going through that, and then I just went back down to Core Health maybe 2 weeks ago to have another mental health eval done, as well as drug eval done, just for to bolster my position with my parenting plan and stuff, to let the court see like what was overlooked. Like, I do not have these problems. I do not have anything. I've gotten my tools and everything set. The stressors like right now would be a big time stressor because I'm a good dad. When I was home.
Let me ask you. So after the attempt to take your life 2 years ago, was there any follow-up mental health treatment?
I was in the state hospital for 2 weeks, and then I was on. I went to weekly appointments. And then me and my baby's mom, we got back together. And so with us being together.
How long did you do the 2 times a week counseling?
About 4 months.
Okay, so you did about 4 months. And then
I'm
after
in
you
the process
completed
of
that,
doing it
then
again to continue right now.
So after that 4 months, so that was about 1.5 years ago, then about 2 weeks ago, you got a new assessment.
Yes.
And have you received any of the
No,
recommendations?
I still have to go into the appointment.
Okay.
And I believe it was
It's mid-October.
Yeah, it's mid-October now.
So where are you with your SUD treatment, substance use disorder?
I'm fine. I'm compliant
Evaluation.
with DOC. I'm on Suboxone. I take weekly UAs for the ideal options for DOC for everybody.
Where are you receiving your Suboxone?
At Ideal Options. I
Ideal
pick it up from Safeway.
Is it a daily dosing?
Yes.
Okay. And how long is your DOC supervision? When did?
Till the 4th, till my daughter's birthday of next year, 4th of January.
Okay. 2025. Okay.
Like I said, it's been a long 2 years. Like the last year and a half, I've basically been at home with my daughter, and upon getting out and making certain that I took care of the rest of my DOC stuff, I came home to a situation that I wasn't really too cool with. And I leave, and then the next time I come back, I'm slammed with no contact orders, and I'm getting calls and another thing she does, she uses them to just out on a whim. Like she started using again. And I think I put that in my parenting plan.
You did.
You know what I mean? I'm just trying to do the right thing. Like, I made mistakes before, and when it became too stressful, I took the cheap route, and thank God I'm still here. You know what I mean? And I've gotten a lot of the tools and everything figured out. You know what I mean? Like my anger issue, like just breathe. You know what I mean? And take care of it. And like with the court thing, 20 years ago, this wouldn't even be an issue. I wouldn't be going to court. I'd be sitting in a prison cell somewhere. You know, I just.
Okay. And then your requests are that the restraining order be dropped to allow for visitation. You're fine with it, keeping it between you and Miss Wilson, but to drop it as to the child. Is that correct?
I'm fine with that. But that's what I was saying too. It's like, I know how I would feel if she had picked my kid up and I wasn't there to give my kid away, give her that last hug or something. She drove off and got hit by a car. That's my only thing is, you know what I mean? If it's kept in place, it's fine. I know how the world is. I have no family left. You know what I mean? That's why this is another big issue, is because I've lost my family on happenstance. You know, I had an uncle and aunt and my little cousin drive down an on-ramp or an off-ramp, and a truck came up the on-ramp and ran over me and killed all of them. You know what I mean? So I understand how that works. And that's my reason.
Okay.
With Nancy. Other than that, I have no issue with having a order with her. I just feel like putting it on my daughter and me was above and beyond, you know what I mean? Because I'm just trying to be involved enough to where I can maybe be in that area where she's not making the right decisions, and she has these people that are not supposed to be around a child in the child's, you know what I mean? And just, I don't know, it's hard for me to explain doing this pro se stuff. But I'm just trying to go the route that I was supposed to 2 years ago.
Okay.
You know?
Mr. Williams, so with the proper service of Ms. Wilson and Ms. Wilson not being present here today, I'm inclined to grant the relief that you're asking for. So I just need a moment to look over things and just kind of make a few adjustments and then talk about that. So give me just a quick moment.
I do know that with school decisions and stuff like that, I would have to be in contact with her, or it's easier, you know what I mean, for stuff, which is like, that's my only thing with the no contact order.
Let me ask you the next step. Appointment of a guardian ad litem. I'm inclined to do that. So what I do is I'll present you 3 names, the next names, and then if you want to strike anyone, you can, and then I'll go ahead and appoint them. So we'll hear from the clerk, and if you can tell me the next 3.
The next 3 names are Sherry Evald, Beth Fellows, and Keith Lawrence.
Any of those you want to strike?
I don't like the name Evil.
Okay, so
but I mean, that don't mean she's bad. I'm not gonna strike her.
yeah. So do you want to strike Miss Evald?
Sure.
Okay, so I'll appoint Beth Fellows as the guardian ad litem. Give me just a moment to fill it out. Paisley is 6 or 8?
She's 8.
8
She
years
turns
old.
9 in January.
Okay. Okay, so I've appointed Ms. Beth Fellows to be the guardian ad litem. She's going to reach out to both you and Ms. Wilson, and so when she reaches out to you, get back in touch with her really fast. And then she's going to just investigate the full best interest of Paisley. And then we'll set a 30-day review on October 30th of this year at 9 o'clock. And that's to make sure that everybody's communicated with her and that she has a path forward. And then I'm going to set a final review date of January 29th, of 2025 at 9 o'clock in the morning. I don't think we need to have an interim review. I just think that if we know that everybody's communicated with her, and then we get the final report date in January, I think that'll be adequate.
I don't know, when can I start seeing my daughter?
Yeah, that's the next step. I'll let you know about that. So the Guardian ad litem, I'm still talking about that. It'll be a county pay case, meaning the county will pay a the full amount on that. So neither party will have to make payment on that. So that'll be filed. Then as far as the requested parenting plan, there's been no opposition lodged. So I'll sign off on the parenting plan on the week on, week off. That'll start this Friday for the week on, week off. And then there's a few other things I'll just mention here. Let me just sign it and then go over that. Mr. Williams, would you be opposed if I included in the parenting plan? You've indicated that you've taken that assessment at just recently, and is it both a mental health and a substance use?
Yes.
It's kind of the dual.
Yes, I went in and on my own volition, both of them.
Okay. Would you be opposed if I just included if there is a recommended treatment that you follow through and complete that? Okay, so I'll include that in here.
Yeah, I have no problem with that.
Okay, so I included that. I'll make a joint decision making as proposed, and I'm just signing off on the rest of the parenting plan. So with that said, I've also signed, there's a temporary family law order that you proposed, and it makes makes reference to the parenting plan. And I've appointed the guardian ad litem, so it makes note of that. So I'll just make a quick correction there. It's not an investigator, it's just to clean up the order a little bit. It'll be guardian ad litem.
You bet you can't get Derek Carr back to the Raiders.
Yeah, I can't do anything about the NFL. The earlier restraining order, and I'll put a date on there so we know which one we're talking about. That was the one that was issued on August 26th, I believe. Okay, so the last bit is that earlier restraining order, the one that was entered in the end of August. I'm removing the child as a protected party, but keeping the respondent, Ms. Wilson, as a protected party. So that means you'll need to have a third party do the communication related to the child. So that type of communication is specifically allowed. Any other third party communication would not be.
All right.
So I'm signing off on both those orders. Do you have any questions?
No, sir.
All right. If you need copies of those, you can check with the clerk's office 2-3 days and get copies.
Okay.
All right. Thank you.
Yep.
I'm here, Your Honor.
Okay, Mr. Williams joins us in the courtroom. Good morning, sir.
Sure.
And then Ms. Wilson, good morning to you. And then it looks like Ms. Fellows is on the line with us. Ms. Fellows, can you hear me okay?
Yes, I can. Thank you, Your Honor.
All right, great. Thank you. So today we're here just to kind of a touch base with everybody on the guardian ad litem. So Ms. Fellows, if you could just let us know if have you been in contact with the parties? How's the communication going? How are things going with getting your report going?
So yes, Your Honor, I was appointed on September 25th. The orders didn't have any contact information, so I had to it was a struggle to get their addresses, but I did manage to find it. I did send out the intake packet on October 9th, emailed the packet to the mother on the 8th of October. I have had quite a bit of contact with the mother. I have just made contact yesterday with the father. He did say that he got the intake packet and he would be getting it to me. I believe he's there in the courtroom, and he said that he would have it. So if he could come by my office, that would be great, because I will be there shortly. So at this point, that's kind of where I'm at.
Okay, great. Yeah, when you were speaking, Mr. Williams held up, it looks like the packet of information.
Yes, I have everything right here. I was under the impression she'd be in court today, so.
Yeah, and it sounds like Ms. Fellows was hoping that you could turn that in today at her office?
I will.
Perfect. And do you know where her office is at?
I don't know where it's at the moment.
It's on the intake packet. My address is.
Okay, let's make sure Mr. Williams.
Okay, then it'd be on the cover sheet then. Yeah, I don't have that with me. I'll just have to run home and grab it.
Ms. Fellows, do you mind just sharing that now, what your office address is, and he can just jot that down or put it in his memory bank?
Sure. Does he have a pen or pencil?
Yeah, I got it.
Looks like a friend's helping.
1655 Hudson Street, number 4, and that's Longview.
Okay, thank you.
1655 Hudson Street, number 4, suite number 4.
Yes.
Okay, great. Perfect. Well, good. And I apologize, Ms. Fellows, that the order didn't have contact information. That slowed things down, but I appreciate your diligence in getting all that information. Mr. Williams?
You're welcome. I'm sorry. I did want to make a comment that the hearing for the final GAL report is not correct. It is on January 29th at 9 a.m., which is the old docket date. So it should be moved, I would think, to 1/27/25. That's a Monday at 1 p.m.
Yeah, that's a good catch. So on the original order appointing, we set a final date where the report would be issued and we'd review it. Since that time, as of November 1st, things are changing as far as docket times and places. And so I appreciate that good catch, Ms. Fellows. So if the parties are comfortable, January 27th, 2025 at 1 p.m. will be the date for the Guardian Ad Litem review. I'm just going to do a quick bench order so we know that that's been changed and updated. Any concerns with that, Mr. Williams?
No, that's fine. I have some things that I have to address with Your Honor before.
Okay. So let me just take care of that right now. And Ms. Fellows, any other items on your end?
Not for me, since this is just the GAL compliance review.
Right. So give me just one moment to write the bench order that updates the next hearing date. Okay, so taking care of that. And then,
Your Honor, can I talk to you real quick? It's Nancy.
sure, and then we'll hear from Mr. Williams because he has some items too. Go ahead, Ms. Wilson.
Oh, thank you, sir. I was never served with any paperwork as of the first court date of this whole situation on the parenting plan. And Cassandra Doble said that she had served me in person. I have proof that I was not at my residence at that time. And
okay.
also, yeah, so I just wanted to state that. And
okay.
I was told that Mr. Williams had warrants out for his arrest, and I don't understand how she was able to serve me when that's his girlfriend and I have a restraining order against him.
Okay. So a lot of things are of concern to different parties at different points in litigation. And if a party has concern about what's happened in the past, any party is free to file a motion asking for any type of relief, and the court can review that. So Ms. Wilson, if that's of concern to you and you want that addressed, then you'd need to file a motion with the court, serve a copy to have somebody serve a copy to Mr. Williams, and that can be heard on a particular docket. So, and we do that just so everybody has an opportunity to know what they're talking about and have a response to it, and then you could reply to their response, and we can take a look at it.
Thank you.
Mr. Williams?
So, Your Honor, as of our last court date, she was served, whether it was her in person or not. You ordered that I was supposed to be able to see my daughter. I went to her school that Friday. She has not been registered in school since the beginning of the year, I was told by the school attendants. I have not seen my daughter. I went and I involved the sheriffs. We went out to Nancy's mother's house because we went with the sheriffs to Nancy's house. She wasn't there. We went with the sheriffs to Nancy's mother's house. She wasn't there. We were told that she could possibly be kept out of state or in Gresham or Hillsborough, whichever one, by the neighbor at Nancy's house. Nancy's mother told the sheriff she knows where she's at. She refuses to inform her where she is. I still have not seen my daughter. I've missed 3 visits now. And Nancy seems to be pulling whatever punches she can to try and get this, whatever. I asked that she be put back in her school because we called the surrounding counties, every county, and no county has a register of my daughter being in school anywhere. And this is of concern to me, as Nancy is known to have like nefarious dealings with people and just, you know, they're hiding my daughter from me.
Okay. So,
Your Honor, can I talk?
No. So anytime that there's a concern whether somebody is abiding by or following a court order or not following a court order, the remedy is to file a motion for contempt. Okay. So if what I see is that there's a parenting plan that was issued on September 25th of 2024.
Yes, sir.
And if that's if the parties feel that that's not being followed, then the remedy or the approach to that would be to file a motion for contempt with the court. Take care of that. Have somebody serve Ms. Wilson a copy of that motion and set it for a docket.
Can I serve her certified mail or email since she's hiding and keeping?
So as far as service, there are certain rules surrounding service that I would encourage you to look at on the court rule webpage. Generally, if a person has responded to the lawsuit and has said, hey, I'm here, they give an address, then with that address, then you can, normally you can serve it with mail. If it's an order to show cause for contempt, then it's an order to the person to show and be physically present. So in that instance, it needs to be personal service.
Okay, is there a way to be given my daughter's whereabouts so that I'm not missing my visits per the parenting plan?
Yeah, my understanding is with the parenting plan that Mr. Williams is the custodial parent.
Yes.
And that the child is to be residing with him, and then with parenting time for Ms. Wilson from every other week from Friday to at the end of school to the other Friday. So it's kind of a week on, week off.
Yes.
Right. So, you know, Ms. Wilson, if there's an order in place, it's expected that everybody's going to follow that order. And if it's not being followed, then, and if there's a motion for contempt, that the court can order sanctions in an effort to encourage parties to comply with what the court has previously ordered. That could include fines, could include incarceration. So if there's an order, that there's a strong expectation that everybody's going to follow that. So at this point,
Can I talk to you, Anna?
no. So Mr. Williams, if you're interested in pursuing that, you can file that motion, have her served, and then she can respond. Ms. Wilson can respond, and then we'll be able to hear her side of the story and her explanation of what's going on.
I'll take care of that then.
So that completes the review of the GAL. I appreciate everybody being present here today. That concludes our purposes for today.
So 1665, suite number 4.
Yep, Hudson, suite number 4.
Okay, thank you, Your Honor.
Martin is on the line.
Thank you.
Stephen Martin, are you
Thank
here?
you.
Ms. Gilmore, are you on the line?
Yes.
Okay, welcome to you, sir. All right. So let me just touch base. It looks like this is Ms. Martin's, your motion related to child support, property, and use of the home. In looking at this, I want to just confer a couple different things. As far as we always look for declarations of service or affidavits of service to make sure that everything you filed has been given to the other side. Did you file one of those?
Yes, I did. So unfortunately, I realized I did not file one until yesterday. The clerk last night said that she would print out and give you a hard copy.
Okay. Okay.
He has been served and has everything.
I believe. So I have your proposed orders here, and I have a vague recollection of receiving. There it is. The personal service, and so then. This looks like service was effectuated on the 12th of September?
Yes, it was.
Okay. And then Mr. Martin, just want to confirm with you that you received a copy of the documents about this case, the motion for the hearing, the proposed parenting plan, child support, and a variety of others.
Yes, sir.
Okay, you got those. And then did you file anything in response to those documents?
No, I didn't. It says on the paper here that written response must be filed with the court no later than 9/11 of 2024. I didn't get this until 9/12.
Yeah, I think you're making reference to the summons that set a date. Is that correct? Okay, so is it your intent, Mr. Martin, to file some type of response?
That was my plan. Yeah.
Okay. So thank you both for that information, Ms. Martin. So generally, with service on the 12th, today, what are we, the 25th, so that's 13 days. So generally, there's under the Court Rule 88, our local court Rule 88 requires a 21-day period. That allows a person from the date of service until the hearing. So that allows everybody, allows the person receiving that information to kind of digest it and formulate a response, serve, and then come back. So we're here just a little bit early as far as the time frames. So if it was on the 12th, if we had 7 days to today's date, we're currently at 13, so it would be 14, 15, 16. I think we'd need to look at setting this to October 9th. That would be beyond the 21-day period. And I recognize you spent an entire morning here, and I apologize for that. But I want to check with Ms. Martin if we were to set it over to the 9th of October at 9 a.m. if that's a date that you would be available.
Yeah, that should be okay.
Okay. And then, Mr. Martin, if it's your intent to file a response, then you'd need to get that response filed by the first week of October, and then serve copies with not only to the court but also to Ms. Martin, and then be here on October 9th. Are you available on the 9th?
Yes.
Okay. All right. So let's do that. That way, when we come back on October 9th, I know what Ms. Martin wants because I've read what she wants, and then I'll have a copy of what Mr. Martin wants or what his response is to that, and then I'll have considered that, and then we can discuss the issues intelligently on that date.
Okay.
Ms. Martin, do you have any questions?
No, I don't think so. I'm pretty sure that me and Mr. Martin is going to work it out between ourselves through mediation.
Okay.
Per agreement between the two of us.
Okay. All right. Yeah. And I said this earlier in the docket. As a general rule, judges are third parties relatively far removed from any situation involving children and a marriage. So if the parties can come to an agreement and feel safe about that and comfortable with that's definitely encouraged. If the parties can't come to an agreement, then court is your other option.
Okay.
All right, Mr. Martin, do you have any final questions?
No.
Okay, well, we'll look forward to receiving your response and make sure you file that with court and provide a copy to Ms. Martin. We'll see everybody on October 9th at 9 a.m.
Thank you.
Thank you.